Hello. Good morning, good afternoon, good evening. How is everybody? How are we? How are we? How are we? Are we excited? We are on the final countdown of the closing arguments. Oh, wait, first of all, hey, welcome to Rush to Judgment with Jessica. I am Jessica. And this is a little channel where, I sit down and, do a little commentary on a few little things that are interesting and entertaining to myself. Hopefully they are entertaining and interesting to you. Hopefully you keep coming back and, like, comment, subscribe, do all of that. It's very appreciative and very helpful. Get this little thing growing and started. So far, this has been real fun and real interesting, and I hope to keep going. But we are going to get started on closing arguments. State goes first with their 2-hour closing statement, closing argument, whatever. Then I guess they're going to do lunch or something. I don't know. And maybe come back and let the defense do some and then or do theirs, and then the state will have their rebuttal. I don't know. They each get 3 hours to do this. I don't know why they would need 3 hours. 3 hours seems super excessive. And it's going to be friggin' Charlie Brown here doing the closing. And I'm pumped to listen to him. So I hope you are too, because this should be fun. But I enjoy closing arguments. I enjoy them more than I enjoy opening statements, really, just because opening statements are cool because it gives you an idea of what's going on or what's going to happen, and hopefully it gives you just a rundown of what everything is about. Closing arguments is when you get to see basically the lawyers act like jackasses and be like, the defense over here is lying to you and this is da-da-da-da-da-da-da. And then they can be big babies and object and do all of that and misstate the law, because nothing in closing arguments is evidence. So they get away with saying things they're not supposed to, because it's also not really a thing to really object during closing arguments unless it is pertinent. So, without further jibber jabber, without the things, let's see how this goes. And I gotta do the things first. I did not come prepared. Did not come prepared. Are we? And I only have him at 0.25 because he talks fast already. Let go.
Back on the record, I believe for the purposes of the jury, I have to have the state rest because effectively there was one rebuttal witness. So they need to know that the state is rested, and then I'll give the closing argument instruction. Yes.
Where are we already approaching? What is this? That's Georgie's mummy. Oh, no, not her. That is the judge.
Device to get on the internet.
Oh,
Good
here
afternoon.
we go. You don't have to talk
A
to him.
teenager is dead.
Oh, dear. Yes.
He is dead through no fault of his own.
Oh,
He is dead because another man made assumptions. That man assumed
Fair.
certain things. He is dead not just because the man made those assumptions, because he acted upon those assumptions. And unfortunately, because his assumptions were wrong, Trayvon Benjamin Martin no longer walks on this earth. The defendant in this case, George Zimmerman, acted upon those assumptions. And because of that, a young man, a 17-year-old man, a barely 17-year-old man, I think he was 3 weeks past his birthday, is dead. Unfortunately, this is one of the last photos that will ever be taken of Trayvon Martin. And that is true because of the actions of one individual, the man before you, the defendant, George Zimmerman.
oh, he's yelling now. He's coming out the gate.
A man who, after shooting Trayvon Martin, claims to not have realized that he was dead. And what did he do? Do you recall what the testimony was about what he did after? Did he render or attempt to render the same aid that those heroic officers from the Sanford Police Department did, who
No.
didn't wear the mask that they normally would wear, but gave mouth-to-mouth, performed CPR in an attempt to bring life back into that young boy? Did he do that? Recall also what happened when Mr. Manalo came out. And recall also what happened when the officer came out and that they handcuffed him. And recall what he told Mr. Manalo, please call my wife. And then apparently Mr. Manalo was taking too long or something. And he said, just tell her I killed him. Just kind of matter of fact.
Well, that's not what he said.
Those acts,
He
those
said,
actions
just tell her I shot someone.
speak volumes of what occurred that evening, Sunday evening. And they speak
Maybe he
volumes of
said-
this defendant's actions.
Maybe tell her I shot someone instead of her thinking someone shot
Sunday,
me.
February 26th,
First lie.
2012, at 7:09
First.
p.m. at the Retreat at Twin Lakes Townhouse.
That's a pretty
Now, you're
shitty
obviously aware.
PowerPoint.
That the shooting actually happened minutes later. In fact, I think because of the recording that was made, we were actually able to precisely determine when that fatal shot occurred. And it occurred at 7:16 and 55 seconds. But I would submit that the events leading up to this murder actually occurred not just earlier that Sunday evening, but months before. And why do I say that? Even
Why
though
do you say
Trayvon
that?
Martin wasn't there months before. Why do I say that the events leading up to this occurred months before?
Because of all of those 911 calls.
You recall the testimony of several people, but most importantly, the evidence you heard from this defendant's mouth when he was being interviewed by Investigator Singleton. When she first said something to the effect of, well, tell me what happened out there. I wasn't out there. I haven't gone to the scene. And what did he first say?
950. This is the correct one? Okay. So you live at 1950 Treeview Circle. Okay. I'm just gonna keep quiet and you tell me the story. You tell me what happened tonight, okay?
Just tonight.
or whatever led up to this. Anything you want to tell me about what happened and why it ended up what it ended up to, where this boy got shot. Okay.
The neighborhood has had a lot of crimes. My wife saw our neighbors get broken into and she got scared.
Are you talking about the residents or vehicles?
The residents,
Okay.
while it was occupied. So I decided to start a neighborhood watch program in my neighborhood.
Okay, what is the name of the neighborhood?
Retreat at Twin Lakes.
Now, those actions,
Gosh darn
whether
it.
sinister or terrible or evil or of ill will, those were actions that occur throughout the United States and many cities, unfortunately, where crimes occur in a neighborhood and people get together and form neighborhood watches or other associations to deal with it. There's nothing sinister or wrong with that. But in this particular case, it led to the death of an innocent 17-year-old boy. Because this defendant made the wrong assumption. He profiled him as a criminal. He assumed certain things, that Trayvon Martin was up to no good. And that is what led to his death. Trayvon Martin, he was staying, he was there legally. He hadn't broken in or sneaked in or trespassed. He was there legally. He went to the 7-Eleven store earlier that evening. He bought what? What did he buy? What was his crime? He bought Skittles and some kind of watermelon or iced tea or whatever it's called. That was his crime.
Sir, read the label.
He had $40.15 in his pockets. He was wearing a photo button.
Who is the photo
and
button?
He was speaking to a girl in Miami. He was minding his own business. But apparently, this defendant decided that he was up to no good, that the victim was up to no good. What had Trayvon Martin planned for that evening? To watch a basketball game with his younger, I guess you'd call him stepbrother or friend, the son of his father's fiance. That's where he was headed back home. You know, this wasn't at 2:00 in the morning or partying somewhere. Not that that would in any way minimize it, but he was just doing a normal everyday thing. He went to the store, got something, got some Skittles and some tea or drink, and was just walking back. Now it was raining. He was wearing a hoodie. Last I heard, that's not against the law.
Shut up.
But in this man's eyes, he was up to no good. He presumed something that was not true. Now, what's ironic about this, neighborhood watch, and you heard from Ms. Dorville and you heard from officers, et cetera, again, that's a respected thing that we encourage citizens to do. But in this particular case, he didn't even bother to find out if he thought he was up to no good. He called the police, the non-emergency number, but then he followed him. He tracked him. Because in his mind, in the defendant's mind, this was a criminal. And he was tired of criminals committing crimes out there. Again, that's not a bad thing.
How do you know?
It's good that citizens.
You weren't in his brain.
But he went over the line. He assumed things that weren't true. And instead of waiting for the police to come and do their job, he did not. Because the defendant, wanted to make sure that Trayvon Martin didn't get out of the neighborhood. You might recall the prior testimony about the prior incidents. What happened? They would commit some kind of crime, apparently, and they would all flee. By the time, I think there was one guy that was caught, but the rest of them would flee. And this defendant was sick and tired of it. So that night,
Why are you
he
yelling,
was
bro?
going to be what he wanted to be, a police officer. Now, police officers are trained. Recall one of the questions that was asked of Investigator Sereno by the defense.
I don't like you
Sir,
yelling.
If you
I don't
drive
think
by,
they want to be yelled
somebody in
at.
the front yard and maybe looking through a window, wouldn't you stop at your car and kind of investigate that? His first, my recollection is that his answer was, I would think maybe he lives there. But see, in this defendant's mind, because of the prior crime out there, he automatically assumed that Trayvon Martin was a criminal. And that's why we're here. That is why we're here. Because the defense is going to argue to you that this was self-defense. And they're going to say, what actually happened at the time of the shooting? And I'm going to talk about that, obviously. But you can't just take that in a vacuum. It's not like this defendant was just walking home and some guy came out of nowhere and just started beating him up. I mean, when you think of it, when you really honestly think about it, who was more scared? The guy, the kid that was minding his own business and going home, that was being followed by another guy in a truck, in an SUV, and that kept following him. Recall what he told Rachel Gentile? This guy was following him, and she said something to the effect of, well, maybe he's like a sex pervert or something. And that's when he referred to, he's a cracker, whatever words he used, and he used the N-word too. But when you think of it,
Creepy ass cracker, that's what he called him.
Now,
It's funny that you can't remember his mean words.
Tell you how he was feeling. And that's true because of the actions of one man, the defendant. Let's talk about the defendant that night. No dispute that he lived there at Retreat at Twin Lakes. No dispute that he was part, I would submit he was the neighborhood watch. But again, that's perfectly good. That's a good thing. But he was upset that burglars got away. That's also a good thing. That's good that people get involved. And apparently, according to his statement, he was driving a Target. Now, he's driving a Target, it's raining, and what does he do? Okay, he calls the police suspicious, but then he tracks this guy down. He tracks Trayvon Martin. He doesn't just call the police and, okay, stay in your car. He keeps following him. And then he goes even further. He gets out of the car. So he sees the victim, he's suspicious of the victim, and then he calls 911, non-emergency. Now, all those actions, no crime's been committed there. There's no crime right there. But it's important to realize this is what led to Trayvon Martin being dead.
Indeed.
The defendant, 28 years old, 5'7", 204 pounds, and armed. Now let me stop right here. He had the right to bear arms. We live in this great country. The Second Amendment allows people to carry a firearm. And he had a permit. He had a right to have a concealed permit, to have a concealed firearm. So again, he is not violating any law. The victim in this case, 17 years old, 5'11", 158 pounds.
There's the hate picture.
And he was unarmed. Well, I guess if you would consider Skittles or the tea a weapon, I'm not trying to make light of it, but the defense is saying, oh, it's that concrete, and we'll talk about the concrete. But what started this? Assumptions, incorrect assumptions on the part of one individual. And again, that's the last photograph we have of Trayvon Martin.
Oh, jeez. You used an autopsy photo? I mean, I get trying to prove a point.
Was profiled as a criminal.
But that's petty, bro.
To quote the defendant.
What happened?
The defendant, Mrs. Zimmer, didn't scream that out. And so the defense will argue, well, that shows that he didn't have any ill will or hatred. No, I would submit to you that he uttered it under his breath. And that itself indicates ill will and hatred. Because he was speaking to the 911 or non-emergency person. But what he was doing is he was verbalizing what he was thinking.
How does anybody tell somebody's ill will?
In his mind, he already assumes certain things.
Why can't I hear you?
You recall the prior calls? We brought in 5, I think defense put in another one 6 within the last 5-6 months, where crimes have been committed in the neighborhood. He was sick and tired of it. But the law doesn't say, okay, take the law into your own hands. Oh, I'm sorry, I got the wrong guy. Oh, I'm so sorry, I thought he was a criminal. Mr. Martin, Tracy Martin, Sabrina Fulton, I am so sorry, I made a mistake. I didn't realize that Trayvon Martin was minding his own business. I am terribly sorry.
Okay.
The law doesn't say that. The law talks about accountability and responsibility for one's actions. And that's what we're asking for in this case. Hold the defendant responsible for his actions. Hold him accountable for what he did. Because if the defendant hadn't assumed Trayvon Martin would have watched the basketball game, George Zimmerman, I'm assuming, would have gone to Target and did whatever he does on Sunday evenings, and we wouldn't be here. The law doesn't allow people to take the law into their own hands. It doesn't allow, quite frankly, even the police to take the law into their own hands.
I
If
would.
police had gotten called out there, they would have done, they would have, okay, what are you doing here? Can I ask you what you're doing? Do you mind telling me? And under the law, they're allowed to ask somebody who's walking the streets. The person can ignore him or not. That's not a crime. Most people say, listen, I live right, I'm right here. I'm going home. You want to come? But this defendant didn't give Trayvon Martin a chance. Recall the testimony of this defendant in terms of the interviews, and I'm going to play certain parts for you. But recall how he says that at one point that Trayvon Martin is circling his car. And my point in saying that is, number one, you've got to determine whether that's true. But let's presume that part is true. And he says he's got something in his hands. Why does this defendant get out of the car if he thinks that Trayvon Martin is a threat to him? Why? Why? Because he's got a gun. He's got the equalizer. He's going to take care of it. He's a wannabe cop. He's going to take care of it. He's got a gun.
Are you yelling?
It's his community, and he's not going to put up with it. And if the police are taking too long to respond, he's going to handle it. Now, did he go over there and say, I'm going to kill this kid? No. This isn't first-degree murder. It's not premeditated. But his actions resulted in the death
Oh, that
of a
guy.
17-year-old boy. Did they not? I mean, do you have an innocent man before you? Is it really self-defense when you follow somebody? First of all, when you profile somebody incorrectly, when you automatically label him a criminal because he's acting in your mind, in his mind, excuse me, as suspicious because he's wearing a hoodie, because it's raining and he's walking the streets or not walking fast enough. I thought in this great country, no matter how stupid we might think somebody's acting because it's raining and he's walking or doing whatever, that's not against the law.
You just called Trayvon Martin stupid.
He did have his hoodie on. It was raining off and on.
Bad luck, bro.
What's ironic in this case, and what I want to spend some time talking with you about, is the defendant's statements. Because you might think, well, hold on. You're the state. What are you putting on his self-serving statements when he's denying committing a crime, when he's saying it's self-defense? We wanted to tell you all the evidence. We wanted to put in all the witnesses that saw something of value out there. Because we wanted you to get the truth. We wanted you to get the complete story. But in doing so, I want to analyze, dissect with you the defendant's statements. Why was it necessary for the defendant to exaggerate everything that happened? Why was it that it took him a while, even at the very end, he kept denying something? What? Obviously, he kept denying that he intentionally killed him, that it was, he said self-defense. But what was important before that? What did he keep denying? That he followed him. Because the defendant knew that if he admitted he followed him, then that showed that ill will.
Stop cutting out.
And that's what we have here, ladies and gentlemen. That's why he kept talking about, oh, I didn't know the name of the street. I was looking for an address. Remember that video? And I'm going to show it to you again, the part where he's walking and he goes to the detectives, like the investigators, like there's some fools or something. Look, this is the back of the houses here. There's no address. Well, right in front of them is an address. And by the way, there's only 3 streets. How difficult can it be? And he's a neighborhood watch. He's been living there 4 years. And he takes his dog down to that dog walk. So he doesn't know the names of the street. He doesn't know the main street that you go in. Because see,
I don't
when you
think it
admit
was
something
the
like that,
street that he was looking
then
for. I
it
think it was
proves
the
one thing,
number
that
of
he
the
was followed.
house.
that he had profiled him and he was
They're
followed.
genius. But
And that shows his guilt.
okay.
Because it shows that his actions led, unfortunately, to the death of Trayvon Martin. So you can't just say, okay, what happened at the actual interaction between them? And again, we're going to talk about that. Because unfortunately, and I stress unfortunately, there's only one person, there's 2 people, one person's not with us anymore, but there's only 2 really people who knew what really happened out there. And he, the defendant, made sure that other person couldn't come to this courtroom and tell you what happened. He, the defendant, silenced Trayvon Martin. But I would submit to you, even in silence, his body provides evidence as to this defendant's guilt. And why do I say that? Because from DNA, from lack of blood, other stuff, his body speaks to you, and even in death, and it proves to you that this defendant is lying about what happened. you recall one of the things we talked about at some point with one of the witnesses, I think it was Dr. DeMaio, a very impressive, distinguished doctor about this photograph the defense keeps parading. Recall what I did? I said, what do you expect? Blood. And I'm going to show you the photographs. Not just at the medical examiners because you're saying, oh, that Dr. Bao, he's incompetent, he didn't know what he was doing. No, I'm going to show you the photographs at the scene, which show what? No blood in his hands. Now they're going to say, oh, it was raining that night. Wow. And I guess the blood on the defendant's side just stuck there, right? But on the victim, they just kind of vanished. Can't have it both. Can't have it like that. See, because what's important is the defendant, in an attempt to convince the police that he was really shooting this man, this boy, in self-defense, he had to exaggerate what happened. That's why he had to at some point say, oh, he was threatening me. It was almost like the levels of fear escalated. And we'll talk about that. How he was then, originally he hit him, and then he got him on the ground, and then there was a struggle, and then he got the upper hand, and then, let's see, it got worse, and then he threatened to kill him, and then he put his hand over his mouth, suffocating him, and then he pinched his nose, and then he went for the gun. See how he's exaggerating everything? Oh, you don't believe this stuff? Well, hold on, it was even more dangerous. Because you know why? This defendant, as you heard, has studied the law in terms of what's required for self-defense. And he's got all those bullet points in terms of what's required.
I don't necessarily think
So,
it was that
If you take
well
one word
played
out
out.
here that I would submit to you shows this defendant's guilt, it's assumptions on the
What
part
are
of
you
the defendant.
doing?
The defendant assumed that the victim didn't belong at the retreat of Twin Lakes, didn't he? That the victim was committing or about to commit a burglary. He assumed and he profiled the victim as a criminal. He assumed that the victim was one of those that always got away. He assumed also that he was an effing punk. And that the victim was going to get away before the police arrived. Now, what did the defendant do? Let's assume he was assuming that. And again, assuming something is not against the law by itself. Unless you're wrong. Let's assume at that time he legitimately thought that Trayvon Martin might be committing a crime. Okay, he called the police on an emergency number. It's a good thing. But what did he do? He didn't, when this victim is coming up to him and he claims circling his car, like, what are you doing, man? What are you following me for? He didn't say, hold on, I'm sorry, I'm with the neighborhood watch. Are can I assist you in some way? You look lost, or you look like you don't know what's going on. Can I help you? Can I give you a ride? And let's say he was scared of him, but he could have said, do you live around here? Can I call the police? Can I call a friend? He didn't do that. He didn't take any action because he already in his mind had assumed that he was a criminal and he wasn't going to give him any benefit of the doubt. He rolled down the window and identified himself as a neighborhood watch to say, listen, I've called the police. I'm not a bad guy. I'm not a pervert. I'm not following you for anything, whatever your name is. Like, you mind waiting? The police are on the way. They're going to be here in about 30 seconds or a minute. Sometimes it takes a
Do
little
you
bit
mind
longer. Would you
waiting?
mind waiting here? I'm a little suspicious of what you're doing. Would you mind waiting?
Okay,
He didn't do that.
yes. Do you mind waiting? I called the police
Did he wait
on
for the
you.
police? No. Did he wait inside his car? No.
That's the dumbest thing I've ever heard.
No. So let's talk about
Please
waiting
stop.
evidence. In terms of what the instructions the court
Please
gave
stop
the
here.
witness, you know,
Please wait for the
with the answers
police
that the witness gave.
that I just called on you because I think you're
Does anybody have interest in
suspicious.
the outcome? And then the evidence agree with the other evidence. Are there prior inconsistent statements? And again, use your God-given common sense.
Well, some people do not have common sense.
What do we have here? Really, what does it boil down to? You heard a little bit, and we put evidence of the fact the defendant at one point wanted to be a police officer. I've been in law enforcement 30 years, prosecutor. There's nothing wrong. That's a good thing. We got to encourage people to be police officers. That's an honorable profession. He applied in Virginia, didn't get in, and then he's doing other stuff. He's getting criminal justice credits. That's good. But again, it doesn't say that the law allows a person to take the matters into their own hand. If not, why are we here? I mean, why do we have courtrooms? Why do we have jurors? Let's just let people handle it.
Why are you yelling?
Oh, they're wrong. Well, sorry. So I want to talk about the witnesses. And before I do that, I want to take a moment to thank you for your time of service. I think we started over 4 weeks ago in this process that we're also fortunate to be able to live in, live the Constitution, in terms of asking people to come from their everyday lives and give up a lot from work and from family to serve as jurors. So I think I speak on behalf of everybody, the defense, the court, and everybody. We thank you for your time and your patience. This case is very important to the state of Florida. It's important to the victim's family. It's important to the defendant. And it's also important, obviously, to you. You probably realized that as you all are watching the witnesses and watching the trial, periodically the attorneys will watch you and the court will. And you guys were very attentive. Some took more notes than others. But without a doubt, nobody was falling asleep. And, it's a long process. You've been here a long time. And we're towards the end.
And here you are just yelling at them.
I want to take a few moments and talk about
It's rude.
what I would submit is how you arrive at a verdict. We ask in this great country for people to serve as jurors without really any legal experience. In a lot of countries, they have lawyers or judges that are already automatically plugged in as such. And that's what they do. They have professional people that sit as jurors. We ask people to come from their everyday lives and sit as jurors. That's what I would submit makes this country great. So how is it that if you're asked to come and you really don't have any legal experience, how do you arrive at a verdict that speaks the truth? How do you arrive at a verdict that is just? I would submit to you to three things. Number one, you rely obviously on the witnesses, the testimony, the evidence that you'll have, the physical evidence that you saw, and you'll be able to digest more if you want to, the recordings, all that other stuff. Number two, you rely on the law that Judge Nelson will read to you, and you'll actually be provided a copy of it. And number three, and perhaps most importantly, you rely on your God-given common sense. That common sense that you just kind of use.
Some people don't have the common
to make decisions
sense.
at home and at work. The law encourages you to do that in evaluating the evidence, determining what's valid, what's not, and what makes sense. And when you do those three things, when you rely on the witness's testimony, the physical evidence, and other stuff, when you rely on the law, and then when you rely and apply your common sense to, I would submit to you, come back with a verdict that speaks the truth, a verdict that is just. And that verdict would be that this defendant is guilty of murder in the second degree. I mean, do you believe that there's an innocent man sitting over there right now? Do you believe that he just assumed something, but he kind of overreacted a little bit, but it really wasn't his fault that Trayvon Martin is dead? Do you believe that this was just kind of a struggle or an argument or a discussion or a fight that just kind of got out of hand? Perhaps. But who started this? Who followed who?
Did you just say
Who was
perhaps?
minding their own business? And again, of the two, who was the one that was armed?
So you just kind of gave him an out.
And
Perhaps.
who knew they were armed?
Doesn't matter. Doesn't matter who started it.
I hope you can see that from there. And I've
If
got
it's
it right here too.
self-defense,
It's a
I could
timeline.
go start a fight.
And it's going to kind of tell you a little bit about what
Pretty
happened.
sure.
It's a timeline
think it
showing you a phone
matters.
call, and you'll be able to take it back there, isn't it?
I would be the
It's a timeline showing
aggressor.
a phone call between Rachel Gentile and Trayvon Martin. There's two parts to it, and it's color coded. Hopefully, we've made it fancy so you all can decipher it. I'm
And then
old and
at the
I'm
end of
getting
the
used to
day,
computer systems, but hopefully it makes sense. And what you also have is George Zimmerman's call, so you have the exact time
Still.
in terms of the length of the call. Then you also have it broke up originally.
I get in a
She was
fight.
on Gentile talked of it. She lost contact and she got it back up. And then you have Ms. Lauer's call.
Oh,
And
now
that's why I was
here's
able
where
to tell
we're
you
gonna talk real
unequivocally as to when the
fast.
gunshot occurred. Because we
Try
were
to
able to
explain
time when Ms. Lauer
things.
made the call and you hear the gunshot
job,
unfortunately,
timeline.
in that call. And then you have other calls too, Mr. Dyka that you heard speak, and then you have when Officer Smith arrived at the between Twin Lakes, and you have Mr. Good's call. So I would submit to you that's relevant in terms of establishing the timeline as best you can as to what occurred. Now, are people off, by a few minutes possibly, but the phone records don't lie. Because my recollection was that we spent, I think, half a day one day and possibly half a day the next day hearing from one witness. Her name was Rachel Gentile. Now, this young lady, I would submit to you, is not a very sophisticated person. She's not the most educated, but she's a human being.
He
She's
said
close to
she's
Haitian,
not
and
the
she happens
most
to be white.
sophisticated
Haitian
person.
or Haitian descent.
That's
And,
rude.
Made a big deal about, oh, you can't read cursive. Yes, you can, unfortunately. She's what, 18, 19? But did what she tell you as best she could, and maybe her English wasn't
That's
the best, maybe her
rude.
speech, her language was a little colorful. I think she referred to me as that bald-headed dude and referred to other phrases to describe other people.
That's not rude.
But did she speak the truth? Because when you think of it, she was the person that was speaking to the victim. And really, the conversation that she had with the victim, nobody would know whether she's telling the truth or not other than her. I mean, we have the phone records that established it, that there's no dispute that they were talking. But what I'm saying is, she didn't have to, she could have embellished. She could have lied about what the victim said. And when she referred to the guy that was following him, that creepy guy, when she said to him, he's probably a pervert or a sexual something. Why is this guy following you? And Trayvon Martin said he's what?
Can't hear you, sir.
I mean, she could have, and nobody would have known the difference. It wasn't like her conversation was being recorded. But see, her use of colorful language doesn't mean that her testimony is less credible. Just because
No,
she's not a
the fact
highly
that
educated individual.
She can't keep her story straight makes her a less credible individual.
Again, we have records that establish that that conversation took place. So there's no dispute about that. And those records are up there. But let's talk about, she spent hours on that witness stand. Why? I guess attempt to discredit her in some way. You decide whether she was telling the truth. Do you disregard what she said because her family's from Haiti? Because she isn't sophisticated? And because she can't read cursive, unfortunately? I mean, is that what you should do? I don't think the instructions are going to tell you that, but you could decide. Well, she's not very educated. I don't think she's, and I'm not saying that you will. But I mean, why do we take so long in asking her questions? Because we're trying to get to the truth, both sides. But I think the other witnesses, I guess, were maybe more sophisticated. It didn't take 6 hours or whatever. Anyway, you decide. But did what she say comport or match up with the evidence that the other people were talking? I would submit it did. I mean, think back, and it happened a while ago, but think about what she said. What she said, Trayvon Martin said, and isn't it consistent with the evidence? I mean, is there any dispute that this defendant profiled, it's my word, you can use whatever word you want to use, but isn't it true that this defendant assumed that Trayvon Martin was a criminal? I mean, he even tells the police that. Why isn't that consistent with what Rachel Gentile tells you? Didn't even the defendant in his statements from the police say, yeah, the kid, or however he referred to him, the guy, whatever, he's running away? Didn't she say that? I had a dream that today a witness would be judged not on the color of her personality, but of the content of her testimony.
What?
On the content of her testimony. Just because she's got a colorful personality, just because she referred to me as a bald-headed dude or whatever, that doesn't mean her story, her statements aren't accurate.
Did you just use a Martin Luther King
Was the evidence consistent with what she
reference?
said? Wasn't she on the telephone with the victim? Isn't it true the defendant was following the victim? Didn't the victim attempt to get away? Didn't the defendant confront the victim? I don't think the defense will admit that. Defendant and the police didn't admit that. But what did he say? Oh, I was just looking for an address. Oh, I was just looking for the street. Oh, you were minding your own business, and all of a sudden, this victim that you were following just decided to all of a sudden attack you out of nowhere. In fact, she went a little further, I would submit. She warned the victim that maybe he was a sexual pervert. And again, colorful words were used by her to describe the defendant in terms of what the victim had described the defendant as. I would submit to you that that's an example that she's telling the truth. Now, she did lie about funeral and about her age originally to the police, to me, to the mother. Why? Okay, she's guilty of that. She didn't want to go have to see the body. She didn't want to deal with it. And she lied to the mother of Trayvon Martin. So you could disregard her testimony because of that. She lied about her age because she didn't want to come forward.
You can also
And she
disregard
realized
her
that
testimony because
I'd have to testify and people would find out that she can't read cursive,
she isn't credible.
unfortunately.
She can't read
Yeah,
cursive, so why did she have her
that's
friend write it in
about that. That's
cursive?
recorded. I believe there might be a dispute as to whether the operator told him not to follow or not. You decide. What was in that recording?
because I can't hear it.
You say that under his breath. Doesn't that kind of demonstrate what the defendant was feeling at the time? I mean, that wasn't information that he was
Black out
providing
the cuss
to
words.
the operator. It wasn't a description so that the officer could identify him, was it? Why is he uttering that word? Other than that's how he feels. Now, defense may get up here and tell you, oh, he was just angry. Well, you decide. I would submit to you.
I don't even think they'll get up and say that he was angry.
That's frustration. That's kind of ill will, hatred, that you've made up your mind he's a criminal and you're tired of these criminals committing crimes. And my God, he's not going to get away.
Are you following him?
George only beats up women. He's so wussy. He doesn't beat up men.
All right, sir, what is your answer?
Why was it necessary to, again, utter the words effing punk? If he hadn't already in his mind determined that
People
he was
cuss.
a criminal.
I cuss a
Trayvon was a
lot.
criminal and he was not going to get away. Recall the testimony in terms of the entrance, and again, we talked about the fact that there's only 3 streets.
Who knows what I would have said? Could have
This is the
said
one, that's circle all the
some
way around, and there's another one.
very not nice words to
Well,
myself.
of course, he claims to not know the street that he comes in and every day in and out, 23 Lane, right here. He claims to not know that street. And ladies and gentlemen, I'm going to show you in that interview, with one of the interviews with the detective in the car leading up to it, he makes reference to the street name. And then like a minute later, he's talking about, I don't know the name of the street. He inadvertently let out that he was aware of that street because he let out that that was a lie that he told the police so that it would justify why he is following, why he is profiling, why he is tracking a young man. And again, that's just a close-up of where this happened right here. And obviously, we're very well familiar with it, and we've got some more exhibits for that. We have Ms. Lauer's call, the 911 call. And really, Ms. Lauer, what did she say? She didn't see anything. She stayed inside. I think at some point in that phone call, she's telling her husband to be, I think they're married now, Jeremy Weinberg. Jeremy, get away from the window, do something, don't go out there. But the bottom line is, she recorded it. But what did she say? Before the actual recording, before she called the police, she heard something going on out there. Because, see, this wasn't like the defendant claims that out of the blue, the victim just kind of attacked him and knocked him to the ground and they just started beating him. No, this started, I would submit, further down, but it didn't start right at the T where the defendant claims it occurred. Mr. Dido, you heard from her too. And we've got the vantage point in terms of there, where her place was. My recollection was she's got the cat, I think his name was Leo, who's got the ledge there. She was kind of looking out and she was reading. At some point she got up, she looked. She had a good vantage point. She did observe something. And what did she tell you? That in her opinion, based on what she saw, she thought the bigger man was on top. And she told you that the voice she heard, she thought was of a child versus an older person. Now, is she an expert? Has she ever heard these voices before? No. She's just telling what she believes. Just like you've had a bunch of other people come in and say, oh, that is George Zimmerman's voice, and that is Trayvon Martin's voice. You decide. But she told you as best she could what she observed. And what's consistent in terms of what she observed and what happened. Because, see, the issue is, at that time, when there was contact between the defendant and the victim, did it occur as the defendant claims? First of all, you'd have to believe that he really wasn't following him, and he was just kind of minding his own business. He was going out for a walk. His walk got interrupted because some guy attacked him. You've got to believe that. You got to believe he wasn't following anybody. He wasn't up to doing anything. He was just kind of minding his own business, and as he was walking back, the victim, for some reason, just decided to go attack him. So you got to have that assumption. It's got to be accurate. And then you got to assume that then the victim just hit him and knocked him to the ground and just started beating him. And poor defendant, poor George Zimmerman, he just kind of took it, boom, boom, just getting whacked over and over. He never did anything. Compare the sizes. And then, at the last moment, he was able to take out that gun. His
George
concealed
does
gun was
have
able
kind
just
of a
to
wimpy
shoot.
voice, FYI.
You have the testimony of John Good, who did call 911.
Had a young child,
And the time frame is important in terms of when he called.
17.
I think in opening statements, the defense told
Had a
you that,
young kid.
represented to you that he is the eyewitness. He is the crucial eyewitness. He's the only eyewitness. I'll take the differ, but again, it's what's important is what you think. Let's talk a little bit about John Good. What did John Good tell you?
I would
He saw what he believed was the victim on top of the defendant. Now, he did not see the shooting. So prior to the
say my
shooting,
son's boy,
I would submit to you when you kind of
17-year-old
put all the
boy,
pieces together,
16-year-old boy.
that there wasn't just like the defendant
George
knocking the victim down to the ground and then staying on top of him and beating the hell out of him. I would submit to you that there was contact between them, that there was a fight, there was a struggle. Ironically, of the two, one of the individuals is the one that's had, what, 18 months MMA fighting? Oh, but of course, he's just a pudgy, overweight man, is I think what Mr. Polley said. He really didn't progress beyond the first level, but he's the one that's had MMA training of some type. But anyway, they interacted, they rolled around, and they fought. But again, you can't just take that in a vacuum. Why did this occur? What led up to this? And at the time of the shooting, was it necessary to shoot him? Well, the defense is going to parade the photographs of the injuries. I don't think I needed to show you the one photo that counts, do I? The ME photo. Who suffered the most serious injury of all? You heard from Ms. Bahadur. What did she tell you? Oh, I apologize, Mr. Good. He said that he saw a struggle out there. He saw the victim, who he believes was a victim, based on clothing description, he didn't know him, on top of the defendant. And he saw the victims doing something to the defendant. He originally said it was MMA style, but when asked specifically, did you actually see blows? He said, no, I saw movement there. He may have been hitting him, but I don't know. What's also very important about what Mr. Good told you? He told you that he could not see the defendant's hands. So did the defendant have the gun out at that point? Was he trying to get it out? And was Trayvon Martin at that point, which is about, what, 25, 30 seconds or so before the shooting, was he trying to protect himself from that gun? Is that what the struggle was about? That at some point, this defendant had the gun? The defendant claims at the very end, right before, unfortunately, he had to shoot the victim, that the victim grabbed the gun. Unfortunately for him, the truth comes out, and it refutes what the defendant said. Recall the testimony of Mr. Gorgon in terms of the DNA. There wasn't any on the gun. Recall what he told his best friend, Mr. Osterman, what the defendant told Mr. Osterman, not like a month later, that same evening, meaning the morning after, when he picked him up at the police station and drove him to his house, that the victim had grabbed the gun. Not the holster, grabbed the gun. Excuse me. In fact, Mr. Osman told you he wrote a book about it with his wife. Ms. Bahadur told you that she heard something out there. I think it was either Ms. Bahadur or Ms. Serdaika heard something like no. I think that kind of matches up with what Rachel Gentile told you about, like, get off of me or something. Like, again, you all took great notes. I'm sure you paid attention to when the witnesses were out there. So I'm not going to cover every little minor point, but it's consistent with what Rachel Gentile told you. And she described, my recollection was that she described, she lives right here at 2841, she described movement this way. Was the victim headed home, as Ms. Gentile told you? And I need to show you the bigger diagram, because you know what's ironic? Is recall, even the defendants from the defendant's own mouth, that they always got away in this exit over here, the other exit, and the victim, you might recall, was staying right here. Was he headed there and the defendant kind of cut him off? But it's consistent with what Ms. Bahadur told you in terms of from her back, left to right. And what did she see? She saw them struggling. That is, defendant and the victim struggling upright. Defendant claims that Trayvon Martin is the strongest guy in the world because he grabbed him, picked him up, and then transported him, what, 20 yards, 30? You saw the pictures, and I'll talk about the diagram, but he claims that he pushed them, or pulled him all the way over here. Recall where all the items are in connection to where the victim ended up? Manolos, Mrs. and Mr. Manolo talked to you about what they observed, what they really didn't observe. My recollection is Mr. Manolo said that the bigger person was on top. They made a big issue, the defense, of cross-examining her. Hold on, but you did see some photographs on TV, and the photographs you saw were Trayvon Martin and showed him playing football in like a football uniform. Yeah, that's true. But I still think the person on top was the bigger person. Now, she didn't see the shooting. My point is that there was a fight there. There was a struggle, and at some points it appears, based on the evidence, that the defendant was on top, and at some points the victim was on top. Wrestling, struggling, whatever you want to call it. But why did it occur? Why did it occur? If you believe he's an innocent man, then you believe that the victim just decided to come up and just smack him. Smack the defendant, and the defendant fell to the ground, and the victim just started beating him up for, we don't know, but for some reason. And that the defendant really wasn't following him. The defendant really was just kind of walking back to his car. The defendant was truthful when he was telling the police that he was just kind of trying to find out what the address was, or he was trying to find out what that street name was. And I apologize. Mr. Manalo told you that he went outside within seconds. I think it was like 20, 30 seconds. And when he stepped outside, he observed the defendant. And he said he thought the defendant was beaten up. He said the defendant was doing something, acting, and then he said he asked him about the phone and talking about calling his wife. And that's when he made that remark. Just tell her I killed him or I shot him. And you might be thinking, well, hold on, if there was a fight, if there was a struggle, how does that factor in? Well, and who started it? Who was following who? Who was chasing who? Who had the right if they were being chased? Does the defendant have the right to self-defense? Does the victim? When he's being chased by this person? You'll hear the facts in this case, and you'll hear in terms of whether the defendant was chasing him or not. You know, it was dark out there. There's no dispute about that. It was raining. No dispute about that. And that's what these photographs show. It shows the distance from the sidewalk or dog walk to where the body was. Shows where several items were. And you've got the diagrams and you've got the photographs. One thing I would submit that these photographs show is the absence of blood on that sidewalk. The other big thing is, if the defendant was really having his head bashed in, as he claims to the police, and he has some injuries to the back of his head, and we'll talk about that, but I think they were, centimeters or less? Why isn't his jacket all torn up, or at least scratched up? If he was being picked up over and over, why is his jacket all right, the back of his jacket? You think about that? Or is he exaggerating what happened? Flashlight, that was with a key ring, and that's the one that was still on. Stage Exhibit 10 showing another angle in terms of the evidence out there. In terms of there apparently was some smoke, and we'll talk about the significance of that because based on what the defendant told police. And again, this is showing Stage Exhibit 15, so the body was covered up. That's the other flashlight that the defendant had, and I think he's told the police that it stopped working or something. If you want to, check again his statements to the police. Was he carrying it in one hand? Why was he carrying it in one hand? Okay, I guess he took it out there to see, track down Trayvon Martin, and then it just stopped working, so he didn't put it in his pocket. I guess he was carrying his hand. That's the victim's phone. There's no dispute that he was talking on the phone. And this is when they attempted to save his life. He was turned over. I'll show you this photograph, not to show you just that, but I show you that because I wanted you to focus on this. He was speaking on the phone, and he had ear plugs, or whatever you call them. Stage Exhibit 22 is a close-up of where the gunshot was, and also this photograph button. One thing I'd suggest to you that might be important to note on that is it was a big deal made about the jacket, or the hoodie, or the sweatshirt, how it had to be consistent with the can and how to do that. Well, that button might have something to do with the way that sweatshirt is kind of hanging. It's a little big on him, but also that might affect the angle of how much is sticking out, the sweatshirt. You decide. State's Exhibit 23, why is that important? You see any blood on his hands? On the victim's hands? State's Exhibit 24, do you see any blood on his hands? I mean, is there any dispute that the defendant's mouth, nose, had some blood on it? How come there isn't any blood on the victim's hands? Because the argument was made or suggested to you in terms of the cross-examination of the medical examiner and all that, oh, you had to wash his hands, so that was inaccurate. You know, you all didn't know what you were doing there. Well, right there at the scene, where was the blood? The other interesting thing is that I will submit to you, just based on the evidence, I don't know what you call this, I don't know if it's a drawstring or what. Why is one of them a lot longer than the other one? Was the defendant maybe pulling on that as the victim was trying to back out? It's ironic that you see how one is pulled all the way down? And which side is it on? State Exhibit 29 to show some of the other exhibits out there. State Exhibit 33, I put this in here because I thought, and we talked about it, I believe it came out during the testimony, that there's a street address right there. That's where the defendant claimed he didn't know the street name, or he couldn't find an address. Even though he's lived out there 4 years, he takes his dog out there, or dogs out there to walk, but he doesn't know that there's street addresses, because this isn't just like some fancy or just regular neighborhood that all the houses are different. These are kind of cookie cutter. They're all the same. But he didn't know the addresses out there, so that's why he had to walk that long distance to find the address or find the street for the police page. State Exhibit 36, those are just some daytime photographs, kind of showing the area in terms of what happened out there. State Exhibit 76, there's been a big issue about that photograph. It shows how the defendant was bleeding. I believe Mr. Manalo took that photograph. Why is the blood still on there, and why would the blood not be on the victim's hands? It's interesting, too, the direction of the blood. We'll talk a little bit about that in terms of what happened. State Exhibit 77. This is, again, Mr. Manalo before the police got out there. Where are the victim's hands? But under his body? What did the defendant claim to you? He used police jargon in terms of suspect and, well, the police, of course, they always spread out the arms, hands to make sure there's no weapon there, because he's trying to tell the police that what happened is he was scared, and he at one point said, oh, I thought he had something in his hand, so I was checking for that weapon. That's what I was doing. Well, it's inconsistent. Physical evidence out there. Now, defense may argue, hold on, didn't Dr. DeMaio say that you could take out a person's heart and then they could live for 15 seconds and the person can kind of walk or do all this other stuff? Okay, so you take out the heart, then the defendant kind of moves him and spreads out his hands, and so he's taking even more blood pumping out, and he's able, and then the victim just kind of happens to just kind of lift himself up and put the hands underneath. I don't know. You decide. Why did he have to say that? Because it's part of him wanting to be a cop. And that's what police officers do. Even when they shoot somebody, they usually handcuff them. Even if the person is dead, I mean, they handcuff them just for security purposes. The other interesting thing is, you recall the flashlight the defendant had in terms of in relation to where the body was. And again, the photograph I showed you, State Exhibit 79, that was showing, I think, one or two witnesses out there, and State Exhibit 80. Those are the two photographs that were showing out there that was taken up, I think, by Officer Wagner. Defendant's gun. You recall what we heard about that from an expert regarding DNA? Swap from the pistol grip matches the defendant. And Trayvon Marks excluded. That is inconsistent with what the defendant claimed to Mr. Osterman. Told the police he was going for the gun. He told Mr. Osterman that he had the gun. He grabbed I think he described what part of the gun he grabbed. And then there's other test results, not limited, and then no determination made on the other side. In the holster. You had also, I would say, relevant to fingernail scrapings of the victim in this case. What were the findings? No DNA foreign to Trayvon Martin, no DNA results at all. So the victim in this struggle that defendant claims he had with him when he was trying to kill him, shut him up so he couldn't speak, where did all the blood go? Where did all the defendant's blood go? While we're on that subject, the defendant claims that he was the only one yelling out there. So all the cries for help were only him. You got to decide whether it was him or whether it was Trayvon Martin or whether it was both of them. Maybe one of them or both. But if he's yelling and if he's down and if he's got all this blood and he's swallowing the blood, how's he able to do all that? And Why is there a consistent in terms of yells of help, help, help? Help? Why isn't it muffled down? Why is he able to yell if the defendant claims the victim was, how's he going to talk? Or is he lying about that? I would submit to you that's another lie. You saw that the hooded jacket was checked, and I'm just giving you very quickly the DNA results. You've got an exhibit there that's got them all in there. But just to demonstrate to you how thorough the investigation was in terms of the Florida Department of Law Enforcement doing their thorough analysis of the case in terms of the evidence. Remember, we figured,
If you're ready to take a break, we'll take a 15-minute recess. Ladies and gentlemen, please put your notepad face down on the chair and follow Deputy Jarvis back into the jury room. Court, please be seated. Court will be in recess for 15 minutes.
Continuation of the closing arguments.
Please be seated. You may continue.
Please report. I'm showing you a photograph of the left hand of Trayvon Martin. And obviously, in addition to the gunshot wound, that was the only other injury that was observed when the autopsy was performed. As you can see from that photograph, there is a very minute or small injury right there, and an even smaller one over here, an abrasion
Here, hand me
on his left hand.
a full laundry
Also, the testimony was that he was right-handed. So if the beating was as severe as I would submit Mr. Zimmerman claims, then how did it occur? I guess maybe, well, we can speculate, but I think even Dr. DeMaio said, well, sometimes you hit something and you don't necessarily injure your hands. That's a possibility. Well, that could also be true for George Zimmerman's hands. The defendant, George Zimmerman, two people, one shot to death and one repeatedly lies about how it happened. Why might that be? You wonder? If one is shot to death and the other one lies, why would that person lie? He brought a gun to a struggle, to a fight that he started by following and wanting to make sure that the victim didn't get away. And now he wants to let you to let him off because he killed the only eyewitness. The victim, Trayvon Martin, who was being followed by this man who had the right to defend himself. Defendant's interview, and you obviously know that he gave various interviews, and I want to just quickly highlight certain parts that I would submit to you are relevant as to establishing why this defendant is lying and why he was caught in numerous lies. And then obviously why it happened.
Sergeant Perks, Officer Buchanan, and I'm the coordinator. And there's been a few times where I've seen a suspicious person in the neighborhood. We call the police, the non-emergency line, and these guys always get away.
What made them suspicious?
Well, what made them
The
suspicious?
recordings of vehicles that come in and out of that
The
neighborhood.
last time they were down, the cameras
It
were
has the
broken.
ability to
why did I put that thing about the camera there? Because as you recall, one of the ploys or tactics that was used by investigator Serena was to say, hey, maybe the victim had a recorder, or maybe somebody videotaped it out there. He, the defendant, knew that didn't happen because he knew about it. He's the one that told the investigators, hey, contact Mr. Taylor or Leland, whatever his name was. I'll give you his number. It's on my cell phone. So he knew that there wasn't any videotaping out there of this. It wasn't like, oh, he took a gamble, and he was really defending himself. And so he said, hey, I'll volunteer. Go ahead and videotape it. Or I wish there was. No, he knew there wasn't any. So it wasn't like he was forthcoming with that information as like a truthful person.
Yes, ma'am.
Okay.
And dispatch asked me where he went. I didn't know the name of the street that I was on.
So you'd come off your street and go into another street?
Yes, ma'am.
Okay.
That goes in, cuts through the middle of my neighborhood.
Okay.
I didn't know the name of the street or where he went. So I got out of my car to look for the street sign and to see if I could see where he cut through so I could tell.
So after you circled your car, he disappeared again?
Yes, ma'am.
Okay.
2 key points there. Didn't know the street name. It's only 3 streets, and he'll tell you, you'll see it actually from his own mouth when he's talking to the investigators out there. He names the street. But no, most importantly also, or just as important, is the fact that he's saying this man, Trayvon Martin, is circling his car. So he's in such dire strait or so fear that he gets out of the car to go follow him. So he's either truthful in saying he's circling the car, or he's lying about it. Either way, it shows that he's not telling the truth. Because if he's really that in fear of, why does he get out of the car? Or is he saying that as another explanation as to why maybe he had to kind of confront him?
Like, got out of the car because he was no longer there.
You see, the victim was already showing that he was going to do something because he starts circling the car. And that's what a person that's about to commit a crime does. That's what he wanted the police to believe.
And find out where he went. And he said, we don't need you to do that. And I said, okay. He said, we already have a police officer en route. And I said, all right. And I had gone through the dog walk where I normally walk my dog, and walked back through to my street, the street that loops around. And he said, we already have a police officer one way. So I said, okay. They said, would you like a police officer to meet you? And I said, yes. And I told him where my car was and the make and the model.
Mm-hmm.
So I was walking back through to where my car was.
Uh-oh. They're still playing. You blinked.
And I said, hey man, I don't have a problem. And he goes, no, now you have a problem. And he punched me in the nose. At that point, I felt that.
So, a few key things to remember there, or point out that I would suggest to you. Number one is where he walks his dog, but he doesn't know the name of the street. In terms of getting there's only, again, 3 streets. Number 2 is he's walking back, even he's told not to follow him. So he decides to obey, even though he wasn't ordered not to follow him, but he decides to go back to the car. When this man came out of the bushes, you will see that he changes that and he catches himself, but you'll see it's coming up. Because number 1 is to where those bushes were, but he also at some point catches himself when he says, I was going towards him. Oh, he came towards me.
Didn't even see him getting ready to punch me. As soon as he punched me, I fell backwards into the grass.
This man, Trayvon Martin, this teenager, came at him. Now, he's out there in the darkness, and he's got a gun, but of course, he hasn't taken his gun out, because that would be illegal. He's got the right to conceal it, because he suspects somebody of a crime. He's not a police officer. He can't go arrest him. But he's just kind of wandering out there in the darkness, even though this guy has circled his car, but he's not in fear. He's just kind of wandering. Does that make sense? He goes out to the darkness like somebody he's scared of, and he's not on guard to what's going on. See, because he's got to convince the police, and by virtue of giving that statement to the police, convince you, the defense has got to convince you that he was just kind of walking and the victim came out of nowhere.
Object, Your Honor. For a moment.
Tell me your legal objection.
Improper presentation of the case law and the law concerning my client's obligations to prove innocence.
Okay, ladies and gentlemen, at the close of the end of the attorney's closing arguments, I will instruct you on the law that's applicable to this case, and you will be given that law back to the jury room to compare with how you find the facts to be. Thank you. Go ahead.
He's trying to convince the police that he hadn't done anything wrong.
And on my nose and on my mouth. And he says, you're going to die tonight. And
Again, now he's saying that the level of violence towards him is escalated. Because Trayvon Martin just decides to shut him up by, and the amazing thing, and I'm going to get to this in one of the slides that you will see, or PowerPoint presentations you'll see, he must have had like 10 hands out there, or 10 arms, because he's able to do all this while the defendant's just sitting there, letting him put his hands over him, not doing anything. Does that make sense?
My jacket and my shirt came up. And when he said, "You're going to die tonight," I felt his hand go down on my side, and I thought he was going for my firearm. So I grabbed it immediately, and as he banged my head again, I just pulled out my firearm and shot him.
Okay. And then what happened?
So the gun wasn't exposed earlier. He's getting beat up, but he hasn't taken the gun out. It's only when the victim starts reaching for the gun. He tells Osman that he actually grabbed the gun or touched it. But he says he's reaching for the gun, and then I realize as he's holding my hand, one hand over my mouth, one hand over my nostril, I can't breathe, but I see it. He's got that third hand that he's going for the gun. Does that make sense? And the victim only went for the gun because the gun became exposed. With the court's permission, I had the deputy check it. The gun. I had to check it again. Thank you, sir. He's got this gun in his holster. And you'll see in a few minutes, maybe more than a few minutes, one of the things that he does, he demonstrates to the police where he had the gun. And it wasn't right here in the front, it was towards the back and it was hidden. And he'll demonstrate to the police out there where it was. Look at the gun. Look at the size of this gun. How did the victim see that in the darkness? Where was it? It wasn't outside. It was tucked in behind. And he'll demonstrate to the police where it was. How did the victim see this gun? Or is it just another lie that he tells?
So I remember once I shot him, I holstered my firearm and I got on top of him and I held his hands on because he was still talking. And I said, "Stay down, don't move." And then
A key point in that is that he tells the officers out there, police station and later out at the scene, that he didn't realize originally that he had shot the victim. Well, if he's in such fear and he doesn't realize he shot him, what the heck is he doing holstering his gun? If he's so scared. Or is that just police jargon? That's what police do when they shoot somebody. First, they make sure the person's either dead or handcuffed, and then they automatically holster the gun. But he's got that police jargon talking, and that's what the police are taught.
And now I'm confused, and now I would like you to.
But if he's so scared, what is he doing holstering his gun? Because he claims at one point that the victim said, "Oh, you got me," or something, and he thought, "Oh, he's scared of him." Because he's trying to convince the police that he really didn't intend to shoot him at that point. That, yeah, he was in fear, but he really wasn't intending to shoot him. He was just trying to kind of scare him, maybe.
recall, it's always dark. They always come around nighttime. And
They always come around at night.
Why does it keep doing that? It's very annoying.
Assumption that he made originally when he profiled a 17-year-old boy that had Skittles. That's the crime he committed that evening. Skittles that he didn't even steal from 7-Eleven. He legitimately bought. You saw the videotape. He wasn't instilling fear into that clerk over there because he was wearing a hoodie. But somehow, this man right here became suspicious of a 17-year-old kid who's wearing a hoodie at 7 in the evening or 7:10 in the evening.
straight through to see if there was a street sign that I could tell dispatch where I lost sight of him at. And when I walked back, that's when he came out of the darkness. And I guess he was upset that I called police.
Now he's starting to speculate or trying to convince the police, oh, I guess that's why he must have attacked me or why he came out, because he must have been upset that I called the police. So he's trying to justify to the police why he did what he did. And of course, it's not that he came to the wrong assumption originally. It's no. I was just checking for the street sign. I was just doing my job as a neighborhood watchman or just a citizen concerned about crime. And I guess he came out of there because he must have realized that I called the police, meaning that first assumption still is existing in his mind. He is a criminal, and that's what criminals do. They don't want to get caught.
Cell phone away.
Okay.
And then when I walked back towards him, I saw him coming at me.
Did you hear that? When I walked back towards him, he switches mid-sentence. I saw him coming towards me. He acknowledges at that point that he is the aggressor. He's the one that's going and pursuing the victim. But he catches himself when he says that, and then he goes, oh, he walked towards me.
And I went to grab my phone. I don't remember if I had time to pull it out or not.
And he claims that he went to for the phone. See, because he's got to then explain why he, being a 5'7", 204-pound, perfectly healthy 28-year-old man, is overpowered by this 5'11", 158-pound kid. And he, being the one that's tracking him or following him, he's on guard. He's got 2 flashlights. He's got a gun. This kid is the one that's scared because this guy's following him. He's got to explain why this kid got the upper hand. Oh, I was going for my phone, and I just got distracted. Was he going for his phone, or was he going for a gun? Were they in the same place?
Well, that's a good question.
Defendant's interview, that same day, part 2. What did he do there? He drew different areas, and it tracks in terms of where he was, where he claims he saw the victim, where the victim just came out of nowhere, where the victim was just kind of looking suspicious. And, you've got that in evidence. I'm not going to spend a lot of time with that, but he drew the different places where he claims the victim was and what, in his mind, caused him to be suspicious of a 17-year-old boy. Defendant's photographs taken of the defendant that you saw. Defense made a big deal. Oh, he was washed up. Well, you've got this bloody photograph here, and you've got that, I guess, and according to Dr. DeMail, I guess one of the EMS people out there just kind of put it back in place, put the nose back in place, because you heard from Ms. Falgate. She didn't see anything. She saw it might be fractured. They don't know. What she recommended is go get x-rays. That's how we verify it. The defendant refused or declined to do that. It's a privilege. But they're going to argue to you.
He didn't have insurance.
Well, first of all, who was following who? Who started the fight or struggle? I circled this because in reviewing the evidence, I thought this might be interesting to you. And what I'm circled up there are his shoes. The defense claims, defendant told the police that he was on his back the whole time and the victim was just wailing on him. Well, and you can look at the actual photograph, there's actually some grass on top and it appears wet, as if maybe he at some point was on top of the victim. Just a minor point, kind of corroborates some of the evidence, the witness's testimony. Second exhibit 52, the back jacket of the defendant. Wow. Where's all the scratch marks? Something to reflect all this tension with these concrete that occurred out there. How come it's missing?
I don't think your clothes get
Back of
scratched.
his head. You recall the testimony? There was 2. How small were they? You recall the testimony of the witness, Ms. Falgate? I think I had her.
They
Tell
were
me
small.
how big it was. And I think she was, it was hard to keep. Anyway, you remember it. Why are his hands
kid?
not injured? If the 17-year-old young man is wailing on him, how come he's not defending himself? And again, these are just little parts of the interview that he gave, and you obviously heard this, so I just want to take you to take a second to read that. But he talks about these guys, he talks about not knowing any places. Again, he's trying to make up one
You
lie
read
after
it.
another after another.
Charlie Brown.
Yeah, he was certainly in my car. As soon as I saw him coming, I rolled up the window because I was so scared of him. Because he was a criminal. I didn't know the name of the street that I was on. And then he talks about, they reminded him, we didn't need you to do that. Had already gone through the dog walk, told him where my car was, make a model, jumped out of the bushes, hey man, you have a problem, and then punched me and fell to the ground. And then he's wailing on my head, and I yelled for help. He grabbed my head and hit it into the sidewalk. When he started doing that, I slid into the grass, still yelling for help. Help, he's killing me. And then, of course, this criminal
You know if this
put
is
his
true,
hands
like
over my mouth and said, "You're gonna die."
It's a traumatic event for him, and he has to sit here and listen to this man
He's
make a
got that
mockery of it.
legal training
Like,
that he's aware of in terms of what he's got to say.
I mean, no matter what the situation was that happened,
The victim said, "You got me after being shot," and he was still talking. I said, "Stay
so
down,
it
don't
is a
move."
traumatic
I got on
event.
top of him. He said, "Ow, ow," and then he talking
And
about
he has
this
to sit here and listen to this bald-ass man make a mockery of the situation.
It's always dark, they always come out around nighttime. And he talks about still not having seen the victim. He was struck in the nose. I screamed out
Drag
probably 50 times. Anything else important?
him
No.
through the
You
dirt.
didn't try to make contact
Like-
with him? No.
I mean, I get it. That's your
And,
job.
you can see the map. You can track down when you look at the timeline in terms of does it match where he's
Yeah.
claiming he's at when he's talking. I would submit to you it doesn't. But again, you rely on what the evidence shows. Came out of the bushes. I don't recall if he came from the front or behind. He punched me in the face and I fell backwards. When I walked back towards him, I saw him coming at me. He catches himself in mid-sentence.
When I walked back towards him.
When I walked back toward him, meaning I was going towards where he was.
Because he was walking back to his car. That's what he said. He walked
And the
that
reason we
way.
get to the
Car was
police, my
back
purpose
this
in
way,
showing
so
you
he
this
was
is
walking
now
back
refers
towards
to the suspect,
that way.
not by my language.
And he was still in this way. So he's walking back towards him. And he came at him. That's what he said. That's what I got. I don't know.
Suspect over and over. Trying to
I
impress the
love
police. Like
how
he
they
knows
just
the stuff. Hey, I'm
Take their
police officer
words
one
and
day.
take them out of context.
Suspect this, suspect that, suspect that. Fired one shot into his torso. He's got all the language down.
That's
The
what he
detective,
did.
investigator Sereno, followed, lost sight, had flashlight, but it was dead. You got a problem? No, you got a problem now. And all of a sudden, it beat him. Started beating him. Smothered by mouth and nose. Felt him slide his hand down. You're going to die tonight, MF. You got me. I spread his hands away from the body. He's still talking, but I don't remember what he said. Let's talk about.
There's been a history of break-ins in that building, and I called previously about this house. When the police arrived at this house, when I called the first time, the windows were open and the door was unlocked. And the police came and secured it. So I said, you know what? It's better to just call. And I kept driving. I passed him, and he kept staring at me and staring around, looking around to see who else was. I don't know why he was looking at me.
Did he walk off from there, or did he stop there last night?
He stopped, and he like looked around, and that's why
This is what he claims this criminal is doing.
Where was he standing at when he stopped?
right
On the sidewalk or in the grass?
Boy, that's a crime at RTL on Sunday night, February 26th. Standing out there in the grass.
And I went to the clubhouse.
He didn't say it was a crime. He said it was suspicious.
And when I got through, I parked at the clubhouse. And they asked me, where I was, and I told them the clubhouse, and I think I gave them the address of the clubhouse.
Where'd you park it?
Right up here next to that green truck. I don't think that truck was there, but I just pulled up.
Okay, so you just pulled in here,
Yes, sir.
and this is where you got out?
No, this is why I just stopped to call him. Then he walked past me, and he kept looking at my car, and still looking around at the houses and stuff. So then the dispatcher said, where did he go? What direction did he go? And I said, I don't know. I lost, because he cut down here and made a right. I guess it's Twin Trees Lane.
Did you catch that? Did you catch him in one lie right there? He originally told the police over and over, before and even after this interview, he didn't know the name of the street. And then
Well,
when
he
started
does
letting him
now.
talk, he gives the name right there. I mean, it's common sense. There's only 3 streets, and he's lived there 4 years. Again, why did he have to lie about that? Because he does not want to admit that he was following this innocent young boy, 17-year-old.
Sir, why?
He made a right in there.
Freaking
And they said, well, what direction is he going? And I said, I don't know. I can't see him. And they said, can you get to somewhere where you can see him? And I said, yeah, I can. So I backed out. And I made this straight. My left hand. parked right about where that sign is, the yard.
In front of the Ford truck.
Yes, and I saw him. And I saw him walking back that way and then cut through the back of the houses. He looked back and he noticed me, he cut back through the houses. I was still on the phone with non-emergency. And then he came back and he started walking up towards the grass and then came down and he circled my car. And I told the operator that he was circling my car. I didn't hear if he said anything.
Right.
But he had his hand in his waistband. And I think I told the operator that. And they said, "Where are you?" And I could not remember the name of the street because I don't live on this street.
Right.
Retreat View Circle goes in a circle.
Right.
And I said, I don't know. And he goes, "We need an address." And I said, "I don't know an address. I think I gave them my address."
What, 2 minutes earlier, a minute earlier, giving him the street name, but now he's telling this investigator that that's the reason why he had to go and follow. I'm sorry, not follow. He had to go find the address because he wants to justify as to why
Sir,
he would
that
go
is a
down that route. Just by
mischaracterization.
coincidence, it keeps kind of tracking where this criminal is going.
Out in
Very
Woodford Street sign.
disingenuous.
So I got out of my car and I started walking.
Go ahead.
I was still on the phone with non-emergency and I started walking.
Okay.
And because I didn't see a street sign here, but I knew if I went straight through, that that's Retreat View Circle, and I could give him the address. Give me the address of the house you're in front of. And there's no address because this is the back of the house.
Did you catch him there? Did you see that? There's a address right there to the right, but of course, he directs the attention to the investigators. See, this is the back of the houses. There's no address there. Like they're just fools.
So I walked here.
He didn't pay attention to that.
I was walking.
Good God.
Watch that it's dead though. And I looked around and I didn't see anybody.
Where?
And I told non-emergency, I said, "You know what, he's gone. He's not even here." So I still gotta use their address, so I walked all the way through. I actually walked all the way to the street and I was gonna give them this address. And they said, "Well, if he's not there, do you still want a police officer?" And I said, "Yes." And they said, "You still want a police officer?" And I said, "Yes." And they said, "Are you following?" Oh, I'm sorry, back there, they said, "Are you following?" And I said, "Yes," because I was, in the area. And they said,
He's only following him because he happens to be in the area.
"We don't need you to do that." And I said, "Okay." So that's when I walked straight through here to get the address so that I could meet the police officer. And then they said, I said, "He's not here." They said, "Do you still want him to come?" And I said, "Yes." And they said, I passed here, I looked, I didn't see anything again, and I was walking back to my truck. And then when I got to right about here, he yelled from behind me, to the side. He said, "Yo, you got a problem?" And I turned around, and I said, "No, I don't have a problem, man."
Where was he at?
He was about there, but he was walking towards me.
Right.
Yes, sir. I believe, like I said, I was already past that, so I didn't see exactly where he came from, but he was about where you are. And I said, "No, I don't have a problem." And I went to go grab my cell phone, but I left it in a different pocket. I looked down in my hand pocket, and he said, "You got a problem now." And then he was here, and he punched me in the face.
Right here.
Right around here. To be honest with you, I don't remember exactly. I stumbled, and I fell down. He pushed me down. Somehow he got on top of me. It was more over here. I think I was trying to push him away from me, and then he got on top of me somewhere around here. And that's my first screaming. Started screaming, "Help!" I was loud as I could.
Notice what's right here. One of those sprinkler boxes things. Would that have caused some of the injury?
And that's when I started screaming for help. I started screaming, "Help!" I was loud as I could. And my jacket moved up, and I had my firearm on my right side hip.
Did you see where he's pointing to? Did you see where he's grabbing, where he's got his firearm?
My jacket moved up, and
See you in
And I grabbed it, and I just grabbed my firearm.
One of his other versions is that he actually grabbed the victim's arm and removed the arm so he would have a better shot. Yeah.
Shit.
He's able to do all this. I guess the victim has 2 or 3 hands or arms. See if that all makes sense, what he's describing.
I said, "Jay, flip him over." I don't remember how I got on top of him. I'm sorry, but I got on his back and I moved his arms apart because when he was repeatedly hitting him in the face and the head, I thought he had something in his hands. So I moved his hands apart.
Yeah, and you saw the photograph taken by Mr. Manalo. Again, lying about that. Because he's trying to justify to the police that he was searching because, of course, the victim had to have something in his hand, meaning some kind of weapon that would have caused him to resort to the shooting him.
He like sat up.
You're still in the position of your place. You're sitting down here, the shot's in the breast.
Yes, sir. He was on top of me like this. I shot him. And I didn't think I hit him. He sat up and he said, "Oh, you got me. You got it. You got me. You got it." Something like that. So I thought he was just saying, "I know you have a gun now. I heard it. I'm giving up." So I don't know if I pushed him off me, fell off me, either way.
First he says he assumed he hadn't shot him, but then he had to push him off of him. Does that make sense? I guess when he said you got him, he kind of fell into him when he hasn't been shot. And again, this is just in written form, some of the stuff
You're asking
we
too
heard,
many questions,
to kind of remind you of some important stuff.
but you're not.
You've also got, and I'm not going to play it for you, but you got a clubhouse video. It's very short. There's clips of it. By coincidence, it appears that there's a vehicle going in it. You might even see a person. Not that you see a full figure. That's just impressions or shadows, but you definitely see a car around the area where the mailboxes are. By coincidence, what Rachel Gentile told you all in terms of where the victim was describing he was. Under that shaded part when it was raining, he was in the mailbox. And he described the defendant looking at him. He kept yelling. That is, he claims the victim kept yelling. Of course, nobody else heard this, but he told the police it happened. Did Mr. Good say anything about when he came out that he heard?
Ridiculous. You're ridiculous.
When you watch the video? You finished the interview on the 29th.
Just so that he's the next, he's that's good.
When that neighbor came up and was talking to me, you got up next to him. Did you get up next to him because you thought he was like, did you position yourself strategically or something?
No, I was just trying to hear what he was saying.
Oh.
He seemed nervous.
Oh.
I didn't think he was like gonna beat you up or nothing, don't you mean?
I thought you were, because the four of you kind of got in between.
That's just natural.
Oh.
Do it so many times, don't we?
Well, you kept your arm away from him.
Yeah, no.
Just a minor point. What was the relevance of that? Why did I think it was important for you to hear again? Because he, in terms of wanting to be a police officer, he wants to know what she was doing to safeguard the firearm when somebody's around. Again, he's trying to talk that police talk. He wasn't trying to be impress these police officers. Like, yeah, I'm one of you all. You know, I can understand police officers and all that stuff. I've got a criminal justice stuff. You know how it is. You just kind of come into contact with people and, sometimes somebody attacked you and all that, trying to befriend them. But he's talking that police jargon. He's curious as to how you do that. The other thing that's important, and you've seen it by the photographs and also by the videos that you've seen, you saw how he was. Because I think Mr. Pollack said, he was this overweight person and all that. Okay, he's a little overweight. Technically, he's 204, I believe, 5'7". But he's fit there when you see him walking around. Because you might contrast that in terms of, if you see him now in terms of big, he was pretty fit then. So compare how he appeared then, and most importantly, compare how Trayvon Martin appeared, the ME photographs.
You're going to go ahead and actually ask this person what he was doing out there? No, sir.
Very basic question. You didn't bother to ask. This guy was suspicious what he's doing, circling the car. You didn't even ask him what he's doing. No, sir. He's a criminal. You don't have to ask a criminal, but you know what they're doing.
So you've had two opportunities to identify yourself as somebody who was actually not meaning to do harm. Probably is that what it in his mind's eye, which I can't get into because he says, that he perceives you as a threat. Okay? He perceives you as a threat,
he has every right to go and defend himself, especially when you're reaching to your pocket to grab a cell phone. Okay.
Very insightful question by Investigator Serino. Like, you're reaching for your pocket and you're like, gun?
Ever say to him, I'm never going to go?
No,
Did it not occur to you?
I said, I don't have a problem, and I started backing away from him.
But you had it in there, Paul. That's why you're pulling, right? You got a concern with him.
I was scared, but
You were
it
scared to
just,
tell them that you had a concern? That you were never going to? You were afraid to tell them that?
yes, ma'am.
I mean, I'm not trying to put you on the spot.
Again, now when they're pressing him on that issue, oh, he's backing away, inconsistent with what he said earlier, then he's scared of them. He's scared of this person that he's following all over in the darkness out there, but of course he doesn't have his gun out, nor does he feel a need to, but he's scared of them. Can't have it both ways.
I'm secure observation. Okay. The locking mechanism, no safety feature methods, is inside your pants? Yes, sir. Okay. I'm over inside your pants. He was mounted on your, you were with him, he was mounted on your upper chest, or, I mean, what something you was a free your waist side to go ahead and pull out your weapon.
When he was mounted on me, but he had pressure on my nose and my mouth suffocating me, and when he, I guess fear, I didn't want to confront him. So the same reason
You were afraid of him.
yes, ma'am.
And do you say he ran?
Yes,
But then you got out of your car and ran after him?
I didn't run after him, no. I walked to find a street name or a street sign, and he had already cut out between the houses. So I knew that if I walked straight through that little sidewalk, I knew that was my street, that I knew to retrieve circle. But
Again, he does not want to admit at all that he is following him or chasing him or profiling him.
Always get away.
No, but that's like, even if he doesn't want to admit that, like, you can. I don't really know that you can't do that. You're not. I can't hear you, Charlie Brown. It's broken. I would like it to come back now.
Again, we've
there
covered
we
this
go.
already, but I just wanted you to be able to read it too. Talking about the video camera. Oh yeah, I wish it was there. He knowing all along that he knew the video cameras, depends on whether they were working or not. And then when they ask him, how do you not know the street name? There's only 3. Oh, I've got it back. Always has an excuse, or they catch him in a lie and he explains it away or tries to. Then when they confront him, okay, hold on, this guy's standing right next to you. Oh, well, he didn't really circle the entire car. And he tries to explain why this individual, Trayvon Martin, is suspicious to him.
Yes, sir.
He's determined to get that address. It's not to go follow the guy. It's not to go follow the victim. It's to just get the address. Yeah. Is it he just wants to catch the bad guy? The guy, the effing punk that gets away? Is that why he's saying that? Then we move on to July 20th, 2013. Mr. Hannity, he's giving him home runs, easy questions. Can't even get that right because he tells one lie after another. Listen.
And then we get to the issue where you said on the 911 call that he's running. You said that to the dispatch. Is there any chance in retrospect to look back on that night and what happened? Trying to maybe get into the mindset, because we also have learned that Trayvon was speaking with his girlfriend supposedly at the time, that maybe he was afraid of you, didn't know who you were. No. You don't think that, why do you think that he was running that?
Maybe I said running, but he was more.
You said he was running.
Yes. It was like skipping, going away quickly, but he wasn't running out of fear.
You can tell the difference?
He wasn't running.
He wasn't actually running.
Sir?
Hannity just asking a very simple question. Well, perhaps Trayvon Martin was scared of you since you're following him and he's running away from you. And so he realizes at that time, the defendant realizes, oh, that doesn't look good because that means I'm chasing him. That means Trayvon Martin is the one that's scared. That doesn't look good for me. So what does he say? Oh, he's skipping away. La, la, la. That's what he's claiming.
the unbuckling of the seatbelt. Here you open the car door, and this dispatch asked you at that point, and this became a very key moment that everyone in the media focused on, and the dispatcher asked you, are you following him? And you said yes. Explain that.
I meant that I was going in the same direction as him, to keep an eye on him so that I could tell the police where he was going. I didn't mean that I was actually pursuing him.
I'm not following my daughter where she's out in the street and I'm scared something's going to happen. I'm just kind of going in the same direction that she's in.
I felt him take, he had, after he couldn't hit my head on the concrete anymore, he started to try to suffocate me. And I continued to push his hands off of my mouth and my nose, particularly because it was excruciating having a broken nose and him putting his weight on it. That's the point in time when he started telling me to shut up, shut up, shut up. And
Why did he tell you to shut up?
I don't know.
Where's all that blood on Trayvon Martin's hands? So is he screaming or not? Because why would allegedly Trayvon Martin tell him to shut up if he's not screaming?
When did he first see your gun?
After we were on the ground, I shimmied with him on top of me, and it made my jacket rise up. And he being on top of me saw it on my right side.
So he's got to explain how this dark gun was concealed, which is concealed in his backside there, how all of a sudden it just became exposed.
To get to the grass? Yes, sir. And how did you do that?
I guess you could say shimmy. I mean, he was straddled on me with his full weight, and I would.
At that point, he's able to just kind of shimmy. Before, he's incapable of fighting back, as he claims the victim is bashing his head over and over. But at this point, he gets, I guess, some strength and kind of shimmies. And then, what does he say?
I feel that it was all God's plan, and for me to second guess it or judge it.
Is there anything you might do differently in retrospect? The time has passed a little bit.
Yes, sir.
You know,
That's a bummer.
I don't know whether I need to comment about that. It speaks for itself. And again, you just heard it. So I'll just put it up there.
That one was a doozy.
Just other parts of the same interview. Mr. Osterman, his best friend, he wrote a book about this experience, about defending. The victim had a slender build. Victim saw the defendant use the phone, followed him in his car first. Then he got out and didn't know the name of the street, tried to establish visual contact within arm's reach, etc. Straddle means knees on the armpit and punching. I guess I might as well do what everybody else does. Final orders are done.
Oh, goody, he's gonna play with the doll too.
But you see what he is saying now? He's saying that armpits. How does he get the gun out?
Why are you yelling?
Armpits. How does he get the gun out?
Jesus. People don't like to be yelled at.
The truth does not lie.
People do.
Earlier, he showed the police where that gun was. So how does he manage to get out and get a perfect shot to the heart of a 17-year-old man? Teenager.
Oh, man. Boy. Teenager. Said the wrong
He
word.
doesn't say he grabbed the holster. He grabbed the gun between the rear sight and the hammer. Now, these are two individuals. That is Mr. Osterman, who is a trained federal agent and who's trained the defendant in terms of firearms, so they know what they're talking about. In fact, he suggested the perfect gun to get. He describes in detail what part of the gun the victim touched. No DNA. Only the defendant's DNA. I guess that got washed away too? Or is it another lie that he tells? Pivot at 90 degrees, etc. Thought he might try to get up again. At some point he goes, I wasn't sure whether he did, but then he holsters the gun. All right, let's talk about ill will. in terms of one of the elements in terms of murder. I'm going through this real quickly. Spent years in college trying to be police officers, dreams of hunting fugitives. Those are some of the documents that were submitted that I don't know you had an opportunity to read or review. Learns all about self-defense law, exactly what you have to say. Talking about here in terms of the fact that the stucco man has actually been involved in catching somebody, so he wants to get credit for it too. He doesn't want to be left out after all. He's the neighborhood coordinator. Of course, he wants to make Trayvon Martin a criminal. And he couldn't find the address. Recall? How he's trying to mislead the police. Oh, see, there's no address in the back of these. Why? If he's not doing anything wrong in following an individual, why does he have to lie about it? Common sense. How many arms did Trayvon Martin need for punching, moving to the sidewalk, grabbing the head, smothering the mouth and nose, grabbing for the gun all at the same time? How many arms did he need? How much supposed activity can be done in 70 seconds? That's what we're talking about. Assuming it began immediately after the Rachel Trayvon phone call. Moves, what, 40 plus feet from where he claims it started? Man, somebody there's the flash. When he claims Trayvon Martin did to him, 25 plus punches, 25 slams. How's he alive? How is the defendant alive? Or is he exaggerating that to justify in his mind what he had to do?
Maybe it felt like that to him.
The wrist lock that he describes. How did he learn that technique? Perhaps it was at the mixed martial arts that he kind of went 3 days a week or 2 days a week, 3 hours, but he really didn't get much training.
He said he didn't go that many days.
Think about the time frame here.
Good God. Were you at the same trial? Did you watch the same
The evidence,
testimony as
agreed, in
me?
terms of the physical evidence and testimony, I'll submit it does. In terms of the guilt of this defendant. You recall Mr. O'Brien, the HOA president there at RTL, what he talked about in terms of the procedures they're supposed to follow in terms of neighborhood watch, et cetera. You recall Ms. Thornville about, follow people, call the police.
You don't follow people.
Second degree murder. State's got to prove 3 elements. The victim, unfortunately, is dead. The death was caused by the criminal act of this defendant, and that there was an unlawful killing of Trayvon Martin by the act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed.
I don't understand. I cannot hear you.
He's a criminal. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act of series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm. I am following this guy. I'm armed, and I'm going to make sure he doesn't get away before the police get here. It's done from ill will, hatred, spite, or evil intent. Defense going to claim, oh, he didn't have any, he was so little upset. Why is he having to utter those things? Why is he having to lie about the whole thing? If he wasn't doing anything wrong in following this victim, why does he have to lie about it? Why won't he admit that he went to follow him? Why does he have to come up with this, I didn't know the street, I didn't know the address? Doesn't that kind of show his mental state?
I don't know. Charlie Brown does
It's
it?
such an issue that the act itself indicates an indifference to human life.
Okay.
And in order to convict him for second-degree murder, it's not necessary for the state to prove the defendant had an intent. It's not first-degree murder. We're not saying that he intended to go and kill him.
Because you wouldn't get that. Actually, you might have had a better
He goes
chance
for a moment.
of trying to figure
It's
that out.
violence of his choices.
Who knows?
Isn't that the truth?
I don't know.
Isn't that the truth? Victim really didn't get to choose anything, did he? Or anyone.
Doesn't choose. I don't know. That's it.
State is, the instructions that the court will read to you will tell you in part that the state is charged this defendant with second-degree murder. The verdict of guilty should be for the highest offense, which is improvement, and there's a lesser included. And Hurricane Katrina wasn't just a thunder shower. In other words, Your duty is, if you find him guilty beyond a reasonable doubt of the highest crime, then if not, then you go to a lesser crime.
And
Manslaughter,
Hurricane
Committing
Katrina
intentional act,
wasn't just a
which resulted in
thunder
the death of a
shower.
deadly
What the
weapon, excusable
fuck does
or
that have to do
unjustifiable.
with
You get
anything?
those instructions too about no action in misfortune, et cetera.
Ridiculous.
The court's going to read the whole instruction to you. In terms of how you decide,
I don't
we'll talk
understand.
briefly about that. So the evidence introduced into it alone,
I don't
basically
understand
decide
the whole
only upon
dick.
the evidence and the instructions. What the lawyers say is not evidence, and you're not even to consider it as such. May not decide because you're biased or sympathy or angry at anyone or feel sorry for anyone. Why do we have such rules?
What if?
What if? That's not a lack of evidence. Could always be more. That's not reasonable. You will not hear, because a lawyer or a Hollywood screenwriter can imagine something more than could be done. You must find the evidence lacking. We don't have a big animation of how it happened. Did anybody see it out there? The defendant told the police this is what happened. There were no eyewitnesses to the actual shooting.
What if
Now-
kind of is?
And again, what's not reasonable? Self-defense. This is what the defendant applied to Virginia. I'm down fugitives, and you'll see the letters, emails, etc. Isn't that true?
Oh, you're so clever. It's a clever guy. It's a cheeky fellow. Aren't you reading it?
Again, the key point is that injuries really are not required. The person is legitimately in fear for their life. But why exaggerate them? Unless he's lying about the whole thing. Yeah, no DNA. Fingerprints also weren't on the gun. Blood wasn't there. Credibility. But should you believe the defendant? Think about this. What a coincidence.
You're not saying words.
Does that make sense? Think of the jacket as he's claiming he's going down an angle. Which way would it go? Would the gun be exposed or just the opposite? Think about this.
Oh, do you have the Arizona can Skittles? Jesus. You're a child.
Doesn't that speak the truth? What a coincidence. The shot. All of a sudden the yelling stops.
I mean, that could apply to both.
You see where some of those injuries are? What, they pick up a sidewalk, or they turn them upside down? Or is it just been scraping and rolling and fighting out there? They both were. I'm wrapping this up, believe it or not, and I thank you for your time and your patience. I ask you to come back with a verdict that speaks the truth, a verdict that is just. You heard from many people in this case, and I've summarized some of them. There's a lot more actually that you heard. We know you paid close attention throughout all these proceedings. Some of the people you heard from were the parents of both the victim and the defendant. Unfortunately, the only photographs left of Trayvon Martin are those ME photographs. I mean, they still got other photographs, and you saw some of them at football when he was younger days, but they can't take any more photos. And that's true because of the actions of one person. the man before you, the defendant, George Zimmerman, the man who is guilty of second-degree murder. Thank you.
Thank you. Ladies and gentlemen, we're going to recess for the evening. Before I let you go, and while you're getting your notepads to be ready to put face down, I'm going to give you my instructions. You're not to discuss the case amongst yourselves or with anybody else. You're not to read or listen.
George showed a bit of emotion there. Shook his head. He said, not me, sir. I am not that one. I am not that one. So, do we close it out or do we go on to the next one? Because the next one is the end and it's only an hour. Let's just get in there. Just get in there. And the verdict will be its own.
Thank you. Ladies and gentlemen, we're going to recess for the evening. Before I let you go, and while you're getting your notepads to be ready to put face down, I'm going to give you my instructions. You're not to discuss the case.
State of Florida versus George Zimmerman.
George present, Your Honor.
Defense is closing. Oh.
Please be seated. Good morning. Welcome back. While you're getting your notes in order, I'm going to ask you my questions.
No.
Morning, ladies and gentlemen.
Good. I'm glad he's
First of all,
doing it.
obviously, as Mr. DeLeon just said, I want to thank you on behalf of Judge Nelson, Mr. Zimmerman, co-counsel Don West, the entire defense team.
He's not going to yell at the jury.
For the last year or so. The prosecution team. And without sounding too over the top about it, sort of the citizens of Seminole County, because you've taken on a responsibility that few people have the opportunity to or the obligation to. And even more so than most, because you may not know this, but most trials last a day or two. They don't last several weeks. And it is very few trials, very few where there is enough of a concern that we have to sequester the jury. So you guys have given us not just your attention during the day, but sort of your life 24 hours a day, even more so in effect than we have. And I appreciate that on behalf of everyone we just spoke about. The whole system only works when it works with you. Strange in the way it sort of happens that we have a system that's been ongoing for a couple of years, and we intentionally bring in people who know as little as possible about the system and tell them to make the most important decisions within it. And that's what we've asked you to do. We, and I have some fears I want to talk to you about in that regard, because when we talked in jury selection, we talked about sort of what this process is and how you have to come to us. I used words like unique, strange even, as far as the system that you're now involved in. We're used to it. We do it every day. Sort of like doctors with blood. You get used to it. It's just part of what you do. We deal with things like autopsy photographs and jury instructions and evidence and witnesses who may or may not remember things or maybe not tell the truth, the witnesses who come with biases. And we come into my office and I look at that and I know exactly how to focus my inquiry because I'm a lawyer. I couldn't do it if I was in a hospital, but I can do it in a law office. And yet we ask you to come in and to take on all of our rules and all of our regulations and to apply them as though you've done it all your life. Yep. And my fear is that that's a very difficult task that we're asking you to do. Because the reason why it's difficult is you're completely unused to it. You don't know how to apply a standard of beyond reasonable doubt. You just don't. You don't know how to wait until you go back in that room to have any thought or any impression about how this case has gone so far. It's impossible. We're not really asking you to do that, but we sort of are. Because what we've said to you is, come from your homes, come from your jobs, sit with us for a month. Get rid of, I guess, almost everything as to how you decide things in your life, except bring your common sense. We've talked about that. Leave that outside. Take on somewhat artificial, and by artificial I certainly don't mean inappropriate or improper, and don't want to diminish it at all, but this sort of unusual standard that we're asking you to take on. And my fear is that you will default to what you're used to. You will default to the idea that you make decisions in a split second like all of us do. That you can't help but have a first impression. If I were to walk in today, let's say, and I, just as an example, walked in like this, walked in the courtroom as a lawyer, you would just have an impression. What God's name is he doing with the sunglasses on, and who does he think he is? What's the pinky ring? I put that on because obviously this case has gotten some publicity. I became known as some pinky ring wearing attorney. It's actually my dad's high school ring. It's never been on my pinky, but that's all it takes is an impression. And we look at people and we keep that with us. So you might have an impression of George Zimmerman. Stand for a second. You might have an impression of him because he's sitting at the defense table. And that maybe, as we talked about, he's not just a citizen accused, but maybe he is a defendant. Maybe he has something he has to defend. Maybe, in fact, if the Justice State Attorney's Office has decided to charge him, he has to do something wrong. Maybe that's an impression that you have. Unfortunately, we're not going to ask you not to have impressions. That's absurd. My fear, as I was telling you about it, is that if that allows you to sort of diminish or minimize your task that you've taken on here, that it works against my client. Because even when we talk about things like common sense, we want you to use your common sense, but be careful with your common sense. I know it's a dangerous thing to say. Be careful with your common sense, because common sense is the way we run our everyday lives, the way we make those snap decisions that we have to make every day in order to work, in order to live, in order to deal with our children and our parents. I mentioned as an example, driving today. You guys didn't drive today, but we did. You presume people are going to drive in the lane and not just cut you off. It's these assumptions that we make. The problem with it. Oh, nice. Well, that's okay. I appreciate you noticing.
Thank you. And I'm sorry to interrupt.
No. I think that, well, we'll wait now because it may have to be restarted, but I'm just going to chat for this. I'll be back. My concern is that it may in fact work against my client, because if you start using those same processes that we're used to every day, to just look at things, make a decision, and move on, that subtly and unintentionally, you're going to minimize or diminish the standard that has to be applied in this case. And I'm afraid of that for this reason. If you do that, not only is it going to go against my client, and I don't want that, but any verdict you come up with is going to be sort of a compromised verdict, a verdict that's not based upon the standards that you agreed to, and I'm not blaming you for not doing it, that you agreed to, and that is the only way that this system really works. We talked about the difference in civil cases and criminal cases in jury selection. We talked about the fact that if this was a civil case, you would go back in the jury room and say, well, the state wants money, and you just got to decide a little more than half, 51%, whatever it might be. And then that's the standard. And we talked that I think that's probably the standard we use in everyday lives. Everything but those most important decisions. Even when the decision is made to move out of state, to come down to Florida, to move your life here, we talked about maybe that's a decision which is sort of similar to a beyond a reasonable doubt. I don't know about that. I think that you make a decision like that, you weigh the consequences, you weigh the possibilities, but you never are certain. You never look at a situation like that and say, I've addressed and resolved all variables, and all variables are resolved in favor of this.
He's a good
What you basically
talker.
do is you look at it, it's an opportunity or an alternative or a necessity. You figure it out, you weigh what you can weigh, you accept what you have to accept, and then you make the decision. I would argue to you, I would submit to you that that's not what you can do here today. I think that what you have to do is be absolutely vigilant, diligent in looking at this case and deciding it with the standard far into you for one that you have to take on. Now, that doesn't mean that you have to go back there and wrestle over whether or not Officer Ramondo, did he have medals on the right side of his chest when he was testifying, or the left side of his chest? So that stuff doesn't matter. But what does matter are those significant issues of whether or not the state has proven their case. And on those essential elements and those essential facts, you have to look at that. Because my fear, Mr. Zimmerman's fear, is failing to do that, you will do some of what the state has asked you to do. For Dyer, when they talked about assumptions, for Dyer's jury selection, they asked you to do it in opening when they yelled those words that weren't yelled. They asked you to do it throughout the entirety of their case. So far, they've even asked you to do it in closing. You are not a premise. The judge is going to tell you what the law is. You've heard beyond a reasonable doubt instructions before. I'm going to spend some time on it again to the extent that my argument or insight or presentation differs from what the court tells you, listen to what the court tells you. If I get too far afield, either the judge or the state will remind me. But within that context, it's a very, very difficult standard. It is one where you have to look at it and be very vigilant to make sure that when you're looking at this case, you're not making the assumptions that help you decide the case. Assumptions presume a lack of evidence, because if you have to presume something, you don't know it. And if you don't know it, it hasn't been proven. And if it hasn't been proven, as the instruction tells you, it's just not there. And you can't consider it. You can't fill in the gaps. You can't connect the dots for the state attorney's office in this case. You're not allowed to. So I'll give you a couple of examples. They're not utterly significant, but I'll give you a couple of examples. What do you know about George Zimmerman? Well, use your memory, but you know he went to college. You know he's a neighborhood watch, and he lived there for a couple of years. I think you know he's married because we mentioned his wife's name, I believe. You know that his mom and dad are still around because they testified. And you don't know a lot more about him than that. You know, I mean, there are a few more things. You'll remember them, and I'm not going to have a complete review of all of the evidence, but you don't know a lot about him. To the extent that there are questions or issues that you don't know about George Zimmerman, we're done with the evidence. You're not getting any more information from the state attorney's office to prove their case against George Zimmerman. Don't assume it. Don't presume it. Don't connect dots. Don't fill in the blanks with anything. I'm not saying that you'll be sinister in doing that. Just saying that no matter what it is, you can't do it. That's when we say to you, this case is to be decided on the evidence presented in court. It sounds sort of grandiose almost. Well, of course, we're going to present on the evidence in the case. There is nothing else. Well, the problem with it is that if you're not careful, as we do in our everyday lives, you will connect the dots when you're not supposed to. You will fill in the gaps when you're not supposed to. You will make those assumptions, some of which the state actually do in the closing. You will do that because you know what? It's natural. It is very natural, but not in a criminal courtroom. It is not only unnatural, it is inappropriate. What do you know about Trayvon Martin? Not much either. But you're not supposed to. What happened that day is what happened that day. But what I don't think you should do is fill in any gaps at all. Connect any dots for him either. For any fact, quite honestly, for any witness. If the decision was made by the state not to present additional evidence to you, do not presume. Do not assume, and do not give anybody the benefit of any doubt except for George Zimmerman. Because, one, you said you would, and two, that's the only way whatever verdict you come up with is going to be just, and it's going to be fair. So, one filter, be careful. Address my fear, if you would, by just being careful, just making sure that when you're back there talking and somebody says, well, you know, he's sort of this, or I really think that one other of you just says, I hear you, sort of thinking it too, can't do it. Let's just take that thought, that very natural extrapolation, and put it to the side. And you might say to yourself, since it's the state who carries the burden alone, you know something? That's what the state didn't give us. That's what they didn't show to us. So let's look at the jury instructions and see if it matters. Does it matter where Officer Armando is wearing his medals? No. But if it is a significant issue, it's something that you need to consider and decide in the case of whether or not George Zimmerman committed second-degree murder, then sit back and say, I have to look at the instructions. And the instructions say that reasonable doubt can come from a lack of evidence as well as it can come from a conflict in the evidence. The reason why we tell you, and you're instructed by the court, that George Zimmerman need not prove anything is precisely that reason. Again, a strange system, anyone with children know that you want to get them separated and you want to get the story from both sides. And then that's the only way you figure it out. And then you know who stole the cookies, who gave the cookie to the other one to cover up the crime, or whatever it might be. You get an idea because you get them both. So why does he have that benefit? Why does he come before you and say, you know what, decided not to testify? And then you get to sit back and go, wait a minute, my assumption is I want to hear from him. Now, this case obviously is different than others because you've heard from him time and time and time again. You've heard from him telling you what happened that night. But you know what? Even if we didn't put on a statement, you still would have to go back there and say, I'm not considering that. Why? Why do we take away that common sense presumption of finding out all the information that we can about a case? Because we've already talked about it. You want to take away somebody's liberty? They got to prove the case. The burden is on the state. And it goes back a long, long way. I've got quote to talk to you about, a couple of them actually. John Adams, 1770, when we sort of started this experiment a couple hundred years ago. God, I guess it's 250 now. It is more important that innocence be protected than that the guilty be punished. Now, if I stop there, it sort of sounds like I'm asking to let my guilty client go. I'm not. He's not guilty of anything but protecting his own life. But the quote continues, for guilt and crimes that are so frequent in this world that they cannot all be punished. But if innocence itself is brought to the bar and condemned, perhaps to die, then the citizens say, whether I do good or whether I do evil is immaterial. For innocence itself is no protection. And if such an idea as that were to take hold in the mind of the citizens, then it would be the end of security whatsoever. I have a quote from my office that talks about that in a different way from the 1700s in Nenagh, where my family came from in Ireland. I was there to visit, but never was there. But it also talked about, this is not a death penalty case, obviously. That was a death penalty case where they were talking about a guy going to the gallows. And the question was condemning somebody and not being absolutely certain as to your decision and sending him to the gallows, not because he was guilty, but because maybe he was innocent and maybe he just didn't know. So that's why we have a system that puts so much of a burden properly on the state attorney's office in this case, to make sure that we don't cut any corners and we don't make any assumptions. And this is a compliment to you because Thomas Jefferson talked about you guys about 200 years ago as well, when he said, I consider trial by jury as the only anchor ever yet imagined by man by which government can be held to the principles of its constitution. That's you guys. I think he was talking about juries in general, but it applies to you as well, because we talked about living the Constitution. Well, planned or not, you guys are it. You are living the Constitution. And we'll go over a little bit of it, but I've talked to you about it already. This is a solemn matter. We don't take this lightly, whether it's through jokes or kidding around, you see us smiling at each other or whatever. This is a serious, serious matter for Mr. Zimmerman. It's an utterly serious matter for you. And I don't say that to scold you into acting a certain way, but just to make sure that we don't do what the state has asked you to do on a couple of occasions now. And you know what? You guys figure it out. It's an assumption. Well, what about this? It's interesting in a case like this because I call this case the bizarro case in my practice because it sometimes seems like it's turned on upside down to me. And not saying that you should agree with that, but just a perspective that I've had in this case. How many could-have-beens have you heard from the state in this case? How many what-ifs have you heard from the state in this case? Well, I don't think, anyway, they don't get to ask you that. I don't think they get to say to you, what do you think? No. What have I proven to you? What have I convinced you beyond a reasonable doubt occurred in this case, so much so that you don't have any reasonable doubt as to those issues that I presented to you? They are supposed to use words like certainty and definite and without question, beyond a reasonable doubt, no other explanation. These are the words and phrases of good prosecutors. I used to be one. I know. I've used them. What aren't good words of good prosecutors are maybe, what if, I hope so, you figure it out, could have been. Because those are the assumptions that please do not make. Do not cheapen your role in this case by doing anything less than holding them to the burden that they said in the beginning of the case they would gladly accept and prove to you. You know, and the upside down nature of it is that's what defense attorneys do. If you really think about it, you want to know some of the underbelly of criminal defense work? We're the ones who live in could-have-beens and what-ifs. Well, you know what? Here's some reasonable doubt. What if, blah, 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 blah. Well, you know, it could have been that it happened this way. And that could have been that reasonable hypothesis of innocence. We'll talk about that in a sec. Actually, not a sec. It's going to be sometime this hour, I hope. It could have been. That's where defense attorneys learn to practice and words that they learn to bring to a jury.
Like, I can't even say nothing. I'm
not going to do any of that with you today.
Very entertained by that.
I want you to know exactly what happened that night. I don't want you to presume anything. I would like you to presume whatever you can for my client's benefit, because after all, that's what good defense attorneys do. But in this type of a case, we're going to do something that will probably upset or enrage defense attorneys anywhere who are listening to this case. Because at the risk of confusing you, I'm going to take a side trip for just a few minutes. And that side trip is going to be, I'm going to take on the obligation to prove to you that my client is innocent. Something I absolutely do not have to do. It is the opposite. And let's talk about what I mean about that. Because, as you know, the state carries the burden. And I'm going to say that probably another dozen times before we're done.
But you should.
And we love our
The state
charts.
has
So I have a chart. I've got a couple of charts for you. First, I have this chart, which tells you what reasonable doubt is. At least it's my argument as to what reasonable doubt is. I think there's an objection before I show it. You want to block a view of the jury?
That's fine, go ahead.
Yeah, well, if this doesn't fix itself in just a second, that might work. Thank you very much. I'm going to use that for something else, I think. Thank you. Graphic understanding of what reasonable doubt is. And if it's wrong, Mr. Guys, we can often talk to you when I'm done, let him point out where it's wrong. And then you can make that decision. But this is what we've talked about.
I like how he does his little burns.
What might
His
happen.
little snark.
And how convinced
Real
you might
subtle.
be. Easy, just not guilty, proven. Highly unlikely, less than likely. I think you get the point. I can read through it and ask you to nod your head in agreement for each one. But the reality is, until you get to the idea, the concept of guilt beyond a reasonable doubt, then you just don't get it. And what happens if you don't get here? What stays in place? It's not a civics exam, but that presumption of innocence that we talked about never dissipates, ever. The presumption of innocence never dissipates until the state proves their case beyond a reasonable doubt, which really makes sense. It took us from the king's days where he decided if you were guilty or not to your days where you get to. So this is what happens in a criminal case. The state has to take you from somewhere down here before there's any evidence, and he's sort of presumed to be not guilty, all the way up the list in your mind, so that you have no doubt to which you can attach a reason or no reasonable doubt to the essential elements of the crime and that George Zimmerman is guilty of second-degree murder. Now, I said to you that I was going to tick off all of my brethren and sisterin, we call it that. That's what I was going to say to you. I was going to spend a few minutes doing something else. I was going to show you or prove to you, and I've got not just my little conversation with you, but we'll start talking about evidence in a minute, of this. I'm sorry, just to... Again, this is what really matters for today, and that is this self-defense. And it's interesting because I actually have another poster I'll show you in a little bit, trying to figure out how to make self-defense make sense to you, because it's sort of like disproving a negative. The state carries the burden, without question, of proving to you beyond a reasonable doubt that George Zimmerman did not properly act in self-defense. And if I misspeak, that Mr. Guy fix it. George Zimmerman is not guilty if you have just a reasonable doubt that he acted in self-defense. This is where I'm going, just so you know. We're going to spend about 10 minutes with me bringing you all the way up to here, proving to you beyond a reasonable doubt that he acted in self-defense. But I don't need to. The state needs to convince you all the way down here. Self-defense likely? It's a reasonable doubt as to self-defense. The self-defense suspected. Well, do you have a reasonable doubt as to self-defense? Not guilty. May not be self-defense, you're not quite sure. Not guilty. Unlikely self-defense, but it might be. You got a doubt as to whether or not it's self-defense? Not guilty. It's less than likely is it self-defense. If this was a 50-50, I wouldn't vote self-defense. This was a civil trial. Highly unlikely that it's self-defense, but I have a reasonable doubt as to whether or not it's self-defense. Not guilty. The state has proven to you, beyond and to the exclusion of every reasonable doubt, that he acted in self-defense properly. I have no doubt, no reasonable doubt, that the state has convinced me he didn't act in self-defense the way he should have, then he's guilty. And only then is he guilty. So, let's talk about my burden to prove to you beyond a reasonable doubt of his innocence. At the risk of confusing you, I'm going to request that you not allow me to confuse you as to the standards. But I want to show you what the evidence has shown concerning my client's absolute, beyond question, beyond a reasonable doubt, innocence. Where shall we start? Well, let's start before the beginning. Let's start with what the state wants you to focus on, that he was a cop wannabe. And he did want to be a cop. He also wanted to be a prosecutor, and he wanted to be a lawyer, and he wanted to continue his education. He wanted to help out his community, and he wanted to help out people like Ms. Bertolon by giving her a lock, and he wanted to be involved. You even heard that he mentored some kids from Officer Serino. Yeah, he wanted to be involved. And yes, he wanted to be a cop. He even applied for it. I think what you also heard, I would argue to you, is you heard from the other officers who actually wanted to be cops and then became cops, that it's a fairly noble profession. It is a profession that its moniker is protect and serve. I think it's apparent that George is willing to serve. I think it is. All the evidence that you do have supports that. And actually, it doesn't support any of the contention that he wasn't. It also supports the contention that he's willing to protect. And I think that's readily apparent from all of the evidence. Keep in mind, the state had the opportunity, no, I take that back. They had the obligation to show you any piece of evidence that they thought was appropriate, that they could, to show you that his actions were inappropriate. And what did they decide to bring to you? 2 professors. A couple more, we'll talk about those. 2 professors who say, oh yeah, I taught him. I don't know if you read that book, and but I definitely, it was in the class, it was an online class, and we spoke about it. And he told me he wanted to be a prosecutor. And I think he said, I mean, after this, he was just, seemed to be easygoing, or I liked him, or something like that, whatever that, the guy who was first on Skype and then on cell phone. Then the other professor they brought in to say to you, oh yeah, I taught him this. And we talked about self-defense. And yeah, we talked about it, and he knew about it. So yeah, that's what they want you to focus on, because this cop wannabe knew what self-defense is. So they have that. What else did they decide to bring you about his background? That he did make it as a cop one time. I think you know that he works as a fraud guy at a mortgage company. And what else did they show you to buttress their position that George Zimmerman is before you acting with ill will, spite, hatred, and just hated Trayvon Martin that night? What are their evidence? I'm not being sarcastic, I might be forgetting some as far as his background. The 5 phone calls to non-emergency. You heard them, you have them in. You know, so you also have the 6th one, because I put that in. Because for whatever reason, the state didn't present to you call number 6. It doesn't support their case, I guess, because it's just him calling, being concerned about the fact that a bunch of kids are playing outside and cars are swinging by them. I'm not complaining, just want to make sure there's some 4-year-olds out there and some 6-year-olds out there. Listen to that, because you haven't heard it. I didn't play it to you, but it's in evidence. I think it just sort of rounds out a little bit. Instead of having 5 or 6, you have 6 of 6, and now you sort of know what the state didn't show you. They don't have to show you good stuff about George Zimmerman, but they did say they were going to seek justice. Let's not forget that. They told you in the beginning of this case that they were going to seek justice. So you have this 5 phone calls and now a 6th one.
There's
I also put into evidence, but didn't shove in front of you yet, but it's here. It's this whole pile of reports, police reports, of what other things happened in the past year at Retreat U area. They're there. I could have brought in Ms. Rump, like the state did, or other people, but we just agreed they would go into evidence, and you have those. And they will show you a lot of alarm calls, a lot of burglaries, the home invasion that Ms. Bertolon suffered through. And they will show you, I think, if you look at this, that in that community, there was a rash of people burglarizing homes. And you know what else it's going to show you? It's going to show you that a lot of the people who were arrested for it, the only people who were found and arrested were young black males. We're going to talk about race in a little bit, too. But they're going to show you. And the reason why I mention that now is we talked about assumptions and what you sort of bring into your world when you come into our world. Because certainly, you heard on the non-emergency call how George acted when he saw Trayvon. We'll get to that in due time. So what else do they have about George Zimmerman and his past that they bring to you? I think that's about it. So I would suggest that that's on the way towards absolute innocence. Why? Listen to the calls. Anger, frustration, hatred, ill will, spite. Get out here and get these guys. I hate these young black males. Or whatever the absurdity is that they want you to get from that. Listen to the calls. Do not allow them to give their words to your ears rather than George's. Listen to what he said. Listen to the cadence of his voice. Listen to what he said. Read those reports. Look at those people who lived through, not many of them were home like Ms. Bertolon, but what they came home to, and then wonder whether or not a frustration in Mrs. Zimmerman's voice is inappropriate or appropriate. So that's his past. So what have they shown you as to how he acted now? And how I convince you of his absolute innocence? Let's go to the 26th. On his way to Target. Undisputed. Does it, I think someone said, Mark Osterman, he does it every Sunday. Just his regiment. Makes his fries, sandwiches in their little plastic containers. That's what he does. So, by the way, as to absolute innocence, tell me the witnesses who said to you that George Zimmerman patrolled that neighborhood. We're going to go over the witnesses. I have a whole PowerPoint presentation. I promised it won't take as long as it took me to make it, to present it to you, but there is not a witness in there. Not one. State's case. Not one who will say to you, George Zimmerman, yeah, the guy wandering around the neighborhood, looking around, talking about bringing your garbage cans or some absurdity like that. Not one witness to suggest that the guy who they want you to believe is a neighborhood watch, cop wannabe, crazy liar. Not one. They may want you to assume that, it would seem. And you would have to assume it because you certainly can't find it. So you'll have to assume that this neighborhood watch guy was just some
Joe Schmo,
crazy guy walking the neighborhood looking for people to harass, except that's an assumption without any basis in fact whatsoever. Not one. Another note from Mr. Guy. If I'm wrong about that, let him tell you. Let's show the point where Mrs. Jones said, well, I was a little bit scared about him. Didn't like the fact that he kept circling in my house. Not one. What do they really have? They have Miss Bertolon. He called Miss Bertolon and said, oh, came over. I heard what happened. Really sorry. Just started his neighborhood watch. When your doorbell told us that there's real problems with these sliding glass doors, here's a lock. And you know what? My wife's home. She works. She's a nursing student or something. She's around. She's home if you need to stop by. Innocence. Pure, unadulterated innocence. I would suggest that that shows to you. Certainly as far as second-degree murder or anything like it. So, in my quest to prove that he's innocent beyond a reasonable doubt, he is on his way to Target and he sees somebody that was suspicious. So does he jump out of his car, unholster his weapon, track him down, shoot him in cold blood? No. He does what he was told to do. He calls non-emergency. Not a big deal. Not an emergency. But he did tell you, of course, in the statements at least, and you know, because it's in those reports, that at that very same house, maybe coincidentally Trayvon Martin, was burglarized a few weeks before with a window open and a door unlocked to the back. Is it inappropriate for that to become a concern of somebody who's concerned about his neighbors? I left my house last week. There was a white truck down the street. I looked at it. I usually took a left out of my driveway. I took a right just because I want to see who it was. There was a pool sign on the side of it, and I kept going. Okay. Well, in this case, he does what? He calls non-emergency, and he says, knowing full well, given the benefit of some of the history the state wants you to use to convict him, that he knows it was being recorded. They say it in the beginning, and he's done it before. So he says on the call what he says. I'm not going to play it for you again. You've heard it more times than most people.
Oh no. Gosh damn it, Bobby.
Of people who in the past have gotten away. So he called, and he spoke to the dispatch, and he went through it. So, looking at the question of whether or not my client is completely innocent, provably innocent, what did he do? Stayed on the phone, cursed. Oh, yeah, definitely cursed. And he cursed towards those people, maybe including Trayvon Martin, by the way, at least him, maybe, because he did match the description, unfortunately, and that's just maybe happenstance. We'll talk more about that, too. So, calls it in and stays on the phone like he's supposed to. Does what he's supposed to. Describe him. Think he's black, after being asked. Black, white, Hispanic. So where is how do we move from, I'm looking at a suspicious guy that I'm not sure, it's raining out. He's obviously not coming in the main entrances. Maybe that's an issue. When you look at those reports, you'll see that there are ingress and egress points, at least there used to be, where some people do come in to do bad things. And he talks to the non-emergency. And he basically stays on the phone all the way through. So where's the guilt? No, that's not my burden. Where's the non-guilt? Well, never screams. Mr. Guy screamed. Honda screamed. George Zimmerman didn't scream on that call. Of course, then to cover up his non-scream, at one point, Mr. Delariano suggests to you that, no cell phone, that what he did was under his breath. As what he wants you to assume within that context is he said it under his breath because he wanted to say it, but he didn't want non-emergency call to hear it. And then he wants you to assume that what that means is guilt. Seriously? Seriously? Here's the way you do that. Effing punks. It's just the fact that he was willing to say it on a recorded call to law enforcement is evidence of non-guilt. It is evidence that he wasn't saying it in a way laced with ill will, spite, hatred, or anything else like that. So, call continues. And now we have the call. Now we have our first very large graphic. This is what happens when you get carried away with graphics. They get 10 feet long. What this is a graphic representation of the significance of the phone call that started at 7:09:34 that night. You will have this back with you so you can sort of go through it. It doesn't include every word that was said back and forth because it would have been 20 feet long, but it does have, I would argue to you or submit to you, it has all of these significant words. So let's sort of go through it. You have the tape, I could play it for you, but you've heard it many, many times. It starts, dispatcher, Central PD, can I help you? And George says, some suspicious guy, whatever. Then he says, note down here that Trayvon Martin is on the phone with Rachel Gentile. That's sort of significant when we get down here, but we'll talk about it as we come down the line. Now he's just staring at me. 7:10:21, so we're looking at it about a little bit less than a minute later. And he's just doing, yes, he's near the clubhouse right now. Yeah, he's coming towards me. There was some confusion, I think, maybe it's been cleared up, that George Zimmerman pulled into the clubhouse, backed down and went down the street, twin trees, and then parked. So this is when he was sitting at the clubhouse. It would seem, it seems to be uncontroverted. And this is on here because the suggestion is that this cop wannabe was just so frustrated, so angry, so full of ill will and hatred, that finally he cracked. Finally he broke. And I'm gonna ask when you go back to figure out where he broke. But maybe this is a spot. Maybe it was just after the dispatch said, okay, just let me know if he does anything else, okay? Now they want you to really focus, we're gonna, in a moment we'll get there. They want you to really focus on the idea that Sean Noffke said, we don't need you to do that, and that was a command of law enforcement and somehow he violated it. We'll get to that. But they don't want you to focus on the fact that this same law enforcement officer says, let me know if he does anything else. So here's a thought. Let me know if I do anything else. Have I done anything else? Please get an officer over here, is his response. evidencing the ill will and hatred necessary that you just want to go kill somebody because you hate them, please, please get an officer over here. Twice. Let me know if he does anything else. Twice. Okay, well, it makes sense. That's, I think, probably what they're supposed to ask. And then the person hearing that says, okay, or does something to let him know. I have a tape of Mr. Del Rionda and John Guy saying it their way, and I was going to play it for you. But it's so irrelevant. It's not evidence, obviously. And what really counts is the way Mr. Zimmerman said it. So listen to the tape. And, you know, see if in that you walk away, just at this point right here, you walk away with ill will, spite, hatred, and just this animus towards Trayvon Martin. Which way is he running? So, not going to do it again, but if I would ask you which way I was walking, and I walked out the door and came back, what information would you have? And I walked out the door. Why? Because you probably watched me do it, because I just asked you, which way am I walking? So, ill will, spite, and hatred, or innocence? I would suggest that at this point, this is a conversation. Don't forget, when they're doing this conversation, they had no idea we were going to be here today. They had no idea that we would have a 10-foot graphic of every sentence that they talked about. They were just talking. What's he doing? Let me know. Where's he now? Which way is he running? And he gets out of his car. Now, at this point, I think the state, maybe this is another break point. Maybe this is a break point where George said, oh, what's the network movie? I have it. I just can't take it anymore, something like that. Maybe that's when it happened. Well, let's see. No, maybe not. Gets out of the car, says down towards the other end of the entrance of the neighborhood. Listen to that. See if there's this crescendo of hatred in his voice. Which entrance? The back entrance. And he says, we just got so used to using this in front of regular people. And just, you know what he said. I'm not going to use the words anymore. Not as oversensitivity to you or to pander to you, but we use the words enough in this courthouse so far. And then he says, are you following him? What does George say? In his anger and hatred and plan to track down and kill this unknown person. Unknown is important because ill will and hatred and spite, it's difficult, don't you think, to really gain that to somebody who you don't even know? How do you actually get to a level necessary for second-degree murder when you don't know the person? But anyway, ill will, spite, and hatred. Has it shown right here? We don't need you to do that. Is that when he says, screw you? I'm sick and tired, I'm not going to take it anymore? No. What does he say? Okay. And we're going to talk about wind noise. Matter of fact, I put into evidence for you to look at. One the state put in, I put in the weather reports for that day. Because strange as it seems, a year and a half later, we want to make sure that you know that it was raining out, even though a bunch of people talked about it. But we also want you to know that the wind was up that night. You'll see that at the time of this event, the wind was about 6.8 to 7.2 miles an hour. I put it in the 27th because you also hear wind during the recreation video. In the phone, you sort of hear the wind. Because the question is, was George Zimmerman tracking? Was he running after him? We know he was following him because he said it. The question is, was he tracking him? And the wind noise, the running noise, make up. I will ask you, as the state did, you guys get to decide that. But what I really wanted to focus on is where this ill will, spite, and hatred comes in. So does it come in here? And then he says, what's your name? George, and he says he ran. Did he say he ran and I'm running? Is there any evidence to suggest? Let me ask you something. Is there any piece of evidence that you have in this case that supports the contention that George Zimmerman ran anywhere, or that he ran after Trayvon Martin after he said, okay? I have another challenge for the state. Let him tell you about it. Let him show you in the record of this case that they have evidence that he ran after Trayvon Martin, walked after him after he said, okay. As if to say, I missed it. Presumption, assumption, connecting the dots, sure. But you agree not to do that. and don't let them let you do that. And then tells him where the address is, apartment number, it's a home. Now, at this point, I think right around here is when he says, well, you still want to have an officer? Oh, yeah. Yes, he says. Okay. Where do you want me to meet him? Clubhouse they talked about, at the truck they talked about. And then I guess in the state's presentation to you, they have said, and maybe will say again, that at that point, that's the ill will, spite, and hatred.
Sorry,
I guess, because at that point he says, no.
Plain and fighting.
No, I'm going to go track him down and shoot him or something. So just have him call me. Don't forget, 16 months ago, regular phone call for Shawnee, sort of a regular phone call for George Zimmerman. And I'll tell you where I am. Big deal made about the recreation video and the numbers right behind them, and the numbers not on the back of it. By the way, one other point on that. Which witness, and this is going to sound as though I'm being a little bit sneaky, so let me premise it with that. Which witness told you that Miss Flowers' lights were on that night? So the numbers that they want you to believe that Mrs. Zimmerman walked by and said, I just want to go after him. Just so we're clear, the witness that showed you that Miss Lauer was here, and the state asked the question of her, just so we're clear, because we really want to prove that he was doing this intentionally and trying to say something that we can catch him on later, please tell the jury that your lights were on that night. They never asked him that. They just didn't. Because they want you to presume and assume and connect the dots and do whatever. Now, is that sort of sneaky? No, sorry.
No.
This is their burden. They have to take away reasonable doubt. They have to look at this case and say to you, ladies and gentlemen of this jury, hi, we're the state. We have proved this case beyond, and to disclose it every reasonable doubt, because we have connected every dot that forms a line that leads to nothing but conviction. And they just didn't. So, now what happens? Along my path towards beyond a reasonable doubt innocence, what evidence do we have?
You too. Quit.
I would contend to you that though there was a minute in this tape, or after this tape, he hangs up 7:13:44. We know Miss Lauer's call to us is 7:16:11. There's some time in there. We know that Miss Lauer heard it about 15 to 20 seconds before she decided to make the call. She testified it took about 25, maybe I think she said 25 seconds to get the phone, dial it, try Jeremy's phone first. That didn't work. Try hers, connect, 30 seconds. Back it up another 30 seconds as to what George Zimmerman was doing. Now, we know that he said at a time that he didn't know that he had to protect his story, that he said that he's still gone all the way to the Tree View Circle, sort of makes sense, I would submit, and then he was coming back with that little baby flashlight, because the other one, the impact weapon that was pointed out by the state, is not used as an impact weapon, this little flashlight on his keychain that he had. So he had this, and it was on. You'll see the pictures of, you know now, I think, the pictures of the darkness that night. One is stunning in that you sort of see, here's the field of flash, and beyond it is almost like this black wall. It was that dark. So yeah, he had his flashlight with him, and he had it on. And if that's evidence of tracking Mr. Zimmerman, let the state prove that to you. So we don't know. Evidence seems to support that George is heading back towards his car, and they don't have one shred of evidence to suggest otherwise. And if they had it, I presume that they would have presented it. So where is it? What evidence do we have that it happened at the T intersection? Well, we have the flashlight. Probably not a bad idea to start there. Because somehow that flashlight got dropped right there. But not just George Zimmerman's story about that is there. We have Jenna Lauer, who said, I heard the noise and it was out that way, sort of towards the T intersection. Did she look? No. Did she hear? Yes. Is she close? Probably. And we have Miss Manalo, opposite side, saying it was off to the right, consistent with the T intersection. We have Miss Sudiker, who, though we had some questions about what she saw and how she saw it, nonetheless, she said it started sort of outside of her window. So we know that the altercation, or certainly seems to have started exactly where George Zimmerman said it started. And that somehow it got dragged down to the area where Trayvon Martin actually was shot. I'm going to show you what Mr. Dorianda mentioned. It's an animation. It's not evidence. It doesn't go back there with you. It's just an overview of some of the evidence and how it may look in the context of it. So if it works, we're going to spend a moment to just look at it. It only runs about a minute and a half. We have a 911 call on it because it's used to sort of set the scene a little bit as far as timing. And I'm going to come back and sort of explain some of why what is in there is in there. Only if it works, though. What's the chance of that?
Kate said, what's the chance of that? It's a good question.
This getting messed up if we disconnect one item and put on another. You don't know, or it shouldn't, Fred? John?
Technology. You can't figure it out.
Okay, a couple of assumptions and a couple of problems with this before we look at it. You see where they started. I have Mr. Martin sort of approaching and coming down the sidewalk. There's questions or conflicts about that. Was it bushes? Was it sidewalk? Was it behind me?
Oh my gosh.
And of course, you can see it. It's lit. If it was real weather and lighting conditions, we would be looking at a black screen. So some artificiality that I've had to include in the animation to show you is just things like that. But
lit.
what I want to look at is how the event may have happened at the T intersection and how things sort of progress from there and how that comports with some of the evidence.
Hi.
Of course.
Stop. I
Or
don't.
not.
Would you stop? Is this comfortable for you? Because it's not for me. Not for me. You could lay down. That's what you could do. You know, it helps if you get a mouse instead of using the stupid little mouse pad thing.
T intersection. The first, there's the shot to the nose, we contend. Number one right there is where the flashlight is found. George's small flashlight is key. I didn't have any movement except to get them to the spot of the eventual shooting because we don't really know what happened. Although George Zimmerman did say that he tried to push him off and tried to push him away. I think in the video there were movements like this. We saw, whatever, somehow they got those 25 or 30 feet to the area where we know things happened because this perspective right here, you see that column on the left-hand side, this is John Good's patio where he was actually standing and he came out. The items match, just so you know, the items match precisely the areas where all the evidence was found, and the numbers match the graphs that are already in evidence before you. So you'll see 8, 1, 2, 3, all of those match up because they came from the same data. What I've done on this is I've now begun the 911 call because it's pretty close to time sync to John Good's event because you remember he testified, he was looking at what he saw, 8 to 10 seconds, he went inside, decided to make the phone call to 911. We use that as about 20 seconds or so. An assumption, I agree, because Jenna Lauer had testified it took her about 20, 25 seconds to make the decision and dial 911. So we sort of had to figure out exactly the timeline as best we can.
Maybe both, I'm not sure. They're just coming screaming outside. Okay, what's the address of it here?
Address was taken out.
Please. Is it definitely like how?
Now this is when, according to Mr. Good's testimony, he came out and saw what he saw. What we've done is take away the animation and just use 3 different figures or positions because this is what he said he saw. He said when he came out, he saw them sort of straddled one on top of the other. And then he saw them move towards the sort of parallel. We were having confusion with horizontal, vertical, parallel, and perpendicular trial, but I think the indication was they were parallel and maybe on concrete. So that's going to come up next.
And like Tom's chamber? Yeah. Okay. And is it a male or female?
The second position where he said this is the mounted position or where the ground and pound was occurring. This is where he said it happened closer up to the cement. Again, consistent with what Mr. Zimmerman was saying when he was talking to the officers. Or you decide if it's consistent or not.
It sounds like a male. And you don't know why? I don't know why. I think they're yelling help, but I don't know. It's almost like, does he look?
The third position is when John Good, as he was leaving, said that they sort of come down away a little bit. Mr. Zimmerman said that he was sort of trying to shimmy or to get off being on the concrete. And this was also put in there. And again, there are some assumptions in this animation because the next position that you're going to see is the position just after the shot. This is the position where we contend the shot happened.
He look hurt. I can't see him. I don't want to go out there. I don't know what's going on.
The angle of those 2 people, obviously one sort of over the other. You remember Dr. DeMaio's testimony and other people's testimony, even Mr. Root, I think, testified that because of the way the clothing is, that if leaning over, it was consistent with the gunshot, that being contact, not pressed to the chest, but contact with the clothing, and then about 2 to 4 inches away from the chest.
There's my name. So you think he's yelling help? Yes. All right, what is your...
Now you see we have George Zimmerman on top with the red. His testimony was, shot him, that Trayvon Martin fell sort of off and to the left. You'll look at the scene photographs where you see Trayvon Martin's feet are sort of in, someone called it a bicycling position. They just, I would argue, consistent with having been shot and fell off to the left, his side, and then fell onto his stomach. George Zimmerman then got on top, as he testified to at least, to move out the hands.
There's gunshots. You just heard gunshots? Yes. How many? There's one.
Now, this right here, by the way, what you're seeing is what it's called a 50 millimeter perspective. The human eye sees things at about 49.5. Well, I can't tell you that because I don't know if that's an evidence. Anyway, it's at a 50 millimeter perspective, similar to what people see when they look, which is what John Good had, and which is what this has right here, because this is Selma Moore's perspective. This is the column that she sort of said she looked out and around, and the timing is appropriate because we had it about 6, 7, 8 seconds from the time of the shot, which is when you remember when Ms. Moore did her sort of walk around in the courtroom. She said, and if you timed it, it was about 8 seconds thereabouts. And she took, hear the shot, react to the shot, walk around, come around, go outside, shimmy through the door, look out, and that's what she saw. So she would have seen, at least according to George Zimmerman's story, she would have seen George on top, spreading out the hands. And she said she saw the foot move. She said that at that point, George Zimmerman sort of got up, looked around. You remember her testimony, and we'll talk about that in a minute as well. So this is what she saw, or at least her perspective. And then,
No, come here.
this is now the rest of the 911 call.
I don't know.
You've heard it. It's not particularly significant to
Get
the
in here
event
now.
because
Jeremy, get.
nobody said that they saw anything of relevance beyond that from this one. Thank you, Your Honor. Let's put this back together. The animation, of course, is just that. It's somewhat made up. I mean, it wasn't that night. It wasn't a videotape, although sure certainly hope that there was. It was Zimmerman, sorry, hope that there was. But it does give an idea, a perspective that at least is consistent with the evidence that was presented before you in the case, because it does show the probability, if not the exact certainty, that this event started at the T intersection or thereabouts, and it started with a shot to the face. Trayvon Martin against George Zimmerman. And then it traveled down those 30 feet or so, however they ended up there. We know that when they ended up there, that the only one who was injured at all, except for the gunshot, was George Zimmerman. And that the only other injury that Trayvon Martin had on him was what seemed to be a fight injury from a couple of scrapes to the knuckle. So again, in my dangerous quest to prove my client's innocence beyond a reasonable doubt, now we get really into what happened. Because you can argue in the state will all you want that George wanted to be a cop. And George's calls to law enforcement in the past just had some seething anger buildup. But don't assume it. Prove it, believe it. Don't prove it, it just doesn't exist. And don't connect those dots if they've not been connected to you beyond a reasonable doubt by the state. So now let's look at what really happened that night. And let's see, the graph is done. So what were these people doing just before? Spend a moment on that to start talking about my client's absolute innocence. There's about a minute and a half, something like that, after George's call, that he was doing something. Whether or not he was wandering up to Retreat View Circle to get an address, whether or not he had that flashlight on looking around a little bit, whether, as he said to the law enforcement officer, I do want to try and figure out where he is. I do want to at least keep him a visual on him, whatever. That was about a minute and a half. It's really interesting as well about the phone calls is what Trayvon Martin was doing. Because we haven't spent a lot of time on that yet, but the evidence is sort of compelling as to what he might have been doing. We know that he was on the phone with Rachel Gentile, and we know that that ended, and we have the times, it's all at a precise time, and it kicked back in. And that she said he was running, which actually coincides pretty straightforward with when George said he was running. Some consistency there. So Trayvon Martin was running, and he was running at about somewhere nearby 7:11:47. Keep that number in mind for me, 7:11:47. Because the altercation, according to Ms. Lauer's phone call, if you sort of look at when her phone call started, back it up to when she heard what she heard, she called at 7:16:11. Give her 30 seconds or so to have started, right? Somewhere around there. We're going to take a break for a couple minutes because I didn't realize I've already been talking for an hour and 20 minutes. So we're going to take a break. But before we take a break, here's what I'm going to do. We're going to sit tight, and we're not going to talk. And I'll tell you when we'll talk again, okay? So try not to do much, starting now. Chad, first witness who we talked to, said he could probably throw a football from the back of his backyard to the T intersection. We actually don't have evidence from the state as to how far that was, but I gave him a little bit of insight. I'm not sure who plays football around here, but nonetheless, this is where he was staying. This is where George's car was parked. This is the T intersection. And Chad could throw a football. He actually probably can't throw a football that far because it's a little bit further than that. But there are some good football players who probably could. He had 4 minutes. And he told Rachel Gentile that he was running. You sort of know, for the most part, what George is doing there. Miss it. But since this is the state's case and not mine, did they show you, tell you, explain to you, give you any insight whatsoever on what Trayvon Martin was doing 4 minutes before that fight started at the T intersection? Do you have a doubt as to what happened and what Trayvon Martin was doing and what he must have been thinking for 4 minutes? Maybe time for a break. I might know.
If you may. Ladies and gentlemen, if you'll please put your notepads face down on the chair, follow Deputy Jarvis down into the jury room. We will take a 15-minute recess.
I goofed. There's a whole nother part 2. It's going to be a very, very long video. Yep. Yep. Yes. Going to be a long video. Long video. Because it's not done yet. Oh, goodness. I don't need to start you over. I just need to go down here. Goodness. Where'd it go? Okay. George, I feel you. I'm tired too. Dude.
Please be seated. Mr. O'Mara, you may continue.
Thank you, Your Honor. 4 minutes. That felt like a long time to you before you took the break that we sat here and did nothing for 4 minutes? You get to think what Trayvon Martin was doing. You get to try and figure out why, when he said, George said at 7:11:40, he's running. $7:15:43, when Rachel Gentile tells you the phone call ended because of a bump. 4 minutes. To do what? To walk home? To run home? 4-minute mile was broken when I was like 12 by somebody. And I think he was in his teens. Don't know if he played football. Don't know if he was a defensive guy on a football team, but I do know that you can run a mile in about 4 minutes if you're in decent shape. So we know
Very
that was the
expensive.
opportunity to go home that he did not.
I
We
don't
know
think
that.
he would have done that.
Because of football throwaway. So let's talk about factual innocence of my client, then I'm going to finally leave this behind. I want to talk about factual innocence. Somebody decided that they were angry. Somebody decided they were ticked off. Maybe somebody decided that they just had ill will, spite, or hatred. For whatever reason, somebody did decide that it wasn't over with the running. Because it wasn't, after all. It had only just begun, right? Isn't that really what happened here? It wasn't some cop wannabe. It wasn't some...
You can't see it.
I've learned about how to talk about self-defense. And oh my God, you forgot to say I have to stand your ground on Hannity. That's convicting.
Oh, God.
You didn't tell Hannity I've heard about stand your ground.
Jeez,
The person who decided that this is going to continue,
You know,
that it
I'm
was going to
tired.
become a violent event, was the guy
I
who didn't
could
go
see it.
home when he
Y'all
had the
couldn't
chance
see
to.
it.
It was the guy who decided to lie in wait,
My
I
bad.
guess, plan his move, it seems, decide what he was going to do, and when. The state told you that he had no decisions. They dared to tell you that Trayvon Martin had no decisions, that my client planned this? Really? 4 minutes. 4 minutes of planning. And they want you to ignore it. I guess, because if you don't ignore that, factual and undeniable innocence. Because with those 4 minutes, now let's use your common sense. Now let's decide what probably happened that night. Because we know the result.
Have any?
Now let's try and figure out the why. George Zimmerman probably heading back to his car, looking with his little baby flashlight at Trayvon Martin a little bit. Maybe. Maybe. Not proven, but maybe.
Baby flashlight. You guys are being so mean to George.
Trayvon Martin, 4 minutes, doing something. And we don't know. We really don't. We know he's on the phone. We know he's talking. We know what Rachel Gentile said he was saying about whatever he called him. And I don't care that he called him some stupid name. He's 17 years old. They get to talk stupidly if they want. I'm okay with that. I'm okay with Rachel Gentile being 16 or 18 or whatever. Who cares? She didn't want to be involved in this case. But the reality of what happened is very straightforward, and it proves absolute innocence. For 4 minutes, Trayvon wanted to do something that led to his confronting George Zimmerman. That, I would suggest, not because George Zimmerman said it. Throw out everything George Zimmerman said. Just forget it for a minute. Just, it didn't exist. He did what I probably would have told him to do if he called me on the 26th that night. Shut up and don't say a word to law enforcement. I'll see you there in half an hour. I would have thrown on a pair of jeans, said goodbye to my wife, and run out the door to go see a potential new client. And I would have said, no, you are not talking to law enforcement. Particularly not looking like you look, and particularly not having just shot somebody, and I don't know anything about it, so hush up. And now tell me. So let's just make believe that happened. Let's just take all of his self-serving, cop wannabe created statements and throw them out. What do we have? You've seen the picture a lot. You're going to see it again. What we do have, and thank God for Jenna Lauer, because when Mike Wagner went to her, can you pick out the guy, the potential shooter? She said, no, go get me a picture. And I'll look at the picture. But somebody who shot somebody, I don't want to go say, I know who that is. So we have this. Interestingly, and thankfully we have this, because if we didn't have this, we would only have the cleaned up photo. The one that doesn't show the significant injury, you know what I'm talking about. The one that says, the nose is sort of back in shape. I don't know who put the nose back in shape. I don't know how it happened, but I do know it did look like that right afterwards. So if Mr. Zimmerman just created all of his statements and we throw them out, we start with this, because this is undeniable. This is significant injury. And then we have the back of his head, and you know all about that already. And what else do we have? We have 40 seconds of screaming. When I first got this case, I thought it was going to come and go in 20 minutes. Because when I found out that there was a 911 call with somebody screaming on it, it was game over. Figure out who it is, and then we're done. Because the alternatives are Trayvon Martin screaming, and my guy is some horrible, extended, torturing, then eventual murderer for 45 seconds. Something, if it was Trayvon Martin, something strange was happening for it to be him. Some bizarre 45-second event where he would scream for help, yet still be able to batter George Zimmerman, but they'll have their theory. I guess they're going to tell it to you in the final closing. Or it was George Zimmerman. And if I could get this to whoever, FBI, let's say, do a little comparison, and we're done. You heard from Dr. Nakasone, unfortunately, it couldn't be done. So now we don't know. Now, as Mr. Dellariano suggested, now you do get to decide, I guess, or not, of course, or not. You just simply get to decide that you can't decide. And then who gets the benefit of that? Mr. Zimmerman. So let's not forget about that standard as I'm wandering you down my little make-believe path of factual innocence. Then what else do we have? We have his initial immediate statement to Mr. Manalo. And the way he looked. Salamora looked like he was beat up. Oh no, he looked like he was bending over. Manalo looked like he was beat up, and he just looked strange. And then of course, Mr. Dellariano said, oh, just tell her I killed the guy. You see, not what he said at all. I think what he said, and use your own memories, was that when Mr. Manalo took the phone because he had to drop it, because Tim Smith was doing what he does as a trained law enforcement officer and said, hands out, on top of your head, behind your back, where's the gun? Drops the phone, Manalo gets it, and says, words to the effect, your husband's been involved in the shooting. And what's the response from George Zimmerman? Tell her I shot somebody. I guess what he should have said, what he was thinking through, what he wasn't thinking through, whatever he was going through, whatever the injuries were, whatever, as Manalo said, he just looked like he was out of breath. He should have said, well, that may sound insensitive a year and a half from now. I should have said that I had to shoot somebody. I don't know what he should have said. He told his wife he wasn't the one shot.
That's what I said.
Unusual, inappropriate. Somebody calls up and says, honey, I was just involved in a car accident. What's your first response? Are you okay? You don't even say, is the other person okay? Right? It's just not natural. You okay? You ever say, oh, well, is the car okay? No. You do what you know. You do what you deal with on a daily basis. Don't tell them involved in a shooting. Well, I shot somebody. So we have that evidence. We have Smith, who says right away he told him he was screaming for help twice. Then we go forward. We have the medical personnel. The going, screaming for help is fun, because here, now the state wants you to say, this mastermind criminal, this guilty beyond a reasonable doubt, second-degree murderer knew at that precise moment that he darn well better say that he was the one screaming. Because after all, he had killed the guy who was screaming, in the state's theory, right? So he knew he took care of that problem. Real problem with that theory, unless the mastermind knew, when Singleton mentioned in their interview that Trayvon Martin had passed, George was affected. I guess it could be part of the mastermind criminal behavior that he learned in community college. I guess it could have been, but let me tell you, if you have a doubt as to whether or not that's true, you need to tell the state, don't ever come back before us again with a case like this. Don't ever do this to us. Because what we really have is what I said a while ago. We have factual innocence.
Again.
You could go back there right now, look at the facts of this case, and say, we're going to flip the standard upside down. We're not going to allow Mr. O'Mara to get an acquittal for his client simply because the state hasn't proven their case beyond a reasonable doubt. We're only going to allow Mr. O'Mara to get his acquittal if he proves to us beyond a reasonable doubt that his client is innocent. And we could, because he is. Because he has to be self-defense. Not the standard, of course. So let's talk about the standard to see how far afield from that very standard that the state is supposed to take on what they actually have accomplished. I'm going to first spend a moment on the witnesses. Real quick, I'm going to get through it as quickly as I can. There's like 50 of them. And I could have the lights dim just a bit, Your Honor. And hopefully this will work. Chad Joseph, I'm just going to go through them. Didn't have much to say. He could throw it about the football field, but that's it. Did you know him to be the sort of stepson of Trayvon Martin? Andrew Gaw, 5'10". That's important. We're going to get to that in a second. You saw him stand next to me, and I did that on purpose to show you that I'm a few inches bigger than he is. And he was 5'10" in the shoes he had on that day. All he really said, didn't know much about that event. Sean Nofke, what did he say? Interestingly, because the first time that somebody was talking to George was this guy. And what did he say? No anger, no animosity, no hatred, no anything in George's voice, quite matter of fact. A person who's trained, by the way, to deal with stressful situations and to understand and to dynamically interact with people on the other line, because sometimes these things turn serious quickly. And what did he say? Nope. He even accepted the reality that George may have misunderstood when he said, which way is he running, that George Zimmerman may have thought, I should go find out. He acknowledged, maybe it was imprecise, whatever. Next witness, Ramona Rumpf. She brought in records custodian for the 5 calls. She also, you'll see the affidavit, I think signed by her, of the 6th call. Listen to it if you want. Nothing to do with burglaries, just George Zimmerman being George Zimmerman. Wendy Dorival, interesting witness. The lady who set up Neighborhood Watch a few months before because, as she said, they looked at the crime stats for that neighborhood and it was being assaulted by burglaries. And something needed to be done. So she went in and she did something. And she told us, who might be suspicious from her experience and training. Remember, this is her love, not her job. She does this as a volunteer because she likes the idea of people being involved in the neighborhood and helping keep crime out of your own home and out of your neighborhood. Some of you don't know, could be a reason for suspicion. A person walking in areas they don't belong. Maybe. Someone walking in the rain without purpose. I don't want to just have you acquit my client because I can show you that Trayvon Martin did something bad, but I'm also not going to allow you or the state to ignore the realities of what actually happened that night. And describe Mrs. Zimmerman, to her knowledge, as meek. The other interesting thing about this cop wannabe, they have the Citizens on Patrol program where you get a uniform, you get a car, little yellow lights on it. They can't be blue lights like we have for true law enforcement, but you get little yellow lights and you get to drive around and act like a cop. And he said to that opportunity to be a cop wannabe in a cop uniform and a cop car with cop lights and probably a little cop computer in his car, or at least a cop clipboard, no. Thanks, but no. I got what I'm doing. I'm working, I'm going to school, and my wife, I don't want your cop car, I don't want your lights, and I don't need your uniform. But this is the guy that the state is telling you, get ill will and hatred out of his cop wannabeism? Really? Seriously. Have they proven that to you? Have they come even close? Except for speculation? How many times did you hear an objection on the stand of speculation? Well, because we're not allowed to do that in court. Can't be a witness up there and say, what do you think? Maybe? Because it's not evidence. And that's why it's not evidence for you. Because then you would go back and go, well, John Doe speculated and the judge allowed it. I guess we can speculate. Absolutely not. Absolutely not. Donald O'Brien, HOA guy, parking committees, George helped him with parking. Cop wannabe? I don't know. Doesn't seem he doesn't want the cop car. Involved, citizen, sure. Any complaints, by the way, that the state brought to you about him just towing cars away or ticketing people, knocking on, get your car off that yellow, anything like that to foster their argument to you that he was doing something wrong? Because remember, we've agreed not to assume. So where's the evidence? And they talked about the 17-year-old burglar getting caught, and thank God the stucco guy caught him. And now George, so Mr. Del Leon says to you that George Zimmerman was frustrated. Oh, I wanted that one. Damn, darn, the stucco guy got him instead. Not going to happen again. Are you kidding me? Are you actually kidding me that the state attorney's office, representing the state, is making that allegation to you? That that's ill will because somebody else caught a burglar? Okay, great. Just tie it together, please. You got 2 dots and they're this far away. Just give me a line. Give me something. Stucco guy caught him. George is frustrated. Anything in between, you tie speculation, assumption, or idiocy? Anything? Sergeant Raimondo, I would want him coming to a car accident that I was involved in. What a guy. What a cop. Did everything he could and did it without even thinking about it. Great cop. Likes his job. Diana Smith. A little bit of just problems with the evidence, the rain, and we'll talk about that. But weather conditions wouldn't allow her to process the items. Touch DNA could have been wiped away, and firearm not given to her. I don't know that it turns out to be a big deal, but there is a lack of evidence here. And we'll talk about maybe why that's there. Who gets the benefit again of lack of evidence? George Zimmerman. Celine Bahadur. You'll have an opportunity, and the instructions will tell you, you assign credibility to witnesses. You decide what to believe and who to believe, and whether or not they're credible. I would suggest that along the theme as we're going, check out this woman's credibility before you accept what she said. You saw her, you heard her, you saw her review all of her statements as I showed them to her. First time, talked to Mr. Del Leon last week, first time in court, what shows up? Oh yeah, left to right. Well, here's a thought. Trayvon Martin was running from left to right when he came back towards the area where George Zimmerman was walking. There's a possibility. Could have been. So I don't know where she fits in, quite honestly. I don't know what she saw, if she saw it, how she saw it, or why she said it a year and a half into it, rather than any other previous conversations with law enforcement or with me. But whatever. Fit it in however you can. Jane Sudeika, so she heard 3 pops. She lying? Oh my God, she's lying because she heard 3 pops. No. Let's get off this lying thing because you have slight inconsistencies. She heard or thought she heard what she thought she heard. Okay, whatever. Reverberations, fright, upset, who cares? She got it wrong. What else she got wrong was she thought the big guy was on top. And of course, actually what she really thought was that Mr. Martin, Trayvon Martin hadn't moved because she saw the whole thing, including the shot, which of course doesn't comport with a 911 call, but again, just stressful time for everybody. She seemed particularly affected by stress. That he was on the ground, never moved, saw the shot was from the top, shot was through the back, and that he never moved. It just doesn't make sense. It's okay. That vantage point that Mr. Root talked about, that movie, I don't know if any of you have ever seen it, but it's a great movie because it really does. One event happens, it's the president getting shot by a marksman. And then there's 7 different people watching it. And everyone has a completely different story. They all view the same event, but they viewed it with their history, with their life experiences, what they were going through that day, and with what perspective they had. And it's just different. That's okay. It happens. Ms. Manalo, She heard voices 20, 30 feet to the right, seems to be consistent with it starting at the T intersection. And of course, what she did was what we all do. And I'm not going to assail her for that, but what she did was make some assumptions based upon some facts that she saw afterwards. Here, it'll take me about 5 minutes to find them. She was looking at pictures of Trayvon Martin when he was 12. I think she said that. So I'll tell you right now, if you looked at me when I was 12 and compared me to anybody, I'm the guy getting beat up. No questions asked. But the reality is that she just had this vantage point of a child at 12 years old getting, I guess, the heck beat out of him by the other guy who was on TV, this big, heavy picture of George Zimmerman. And she acknowledged, now that you showed me the other picture, now here's the ones that I did look at and find out or think that it was Trayvon Martin being a small guy. Now that you show me these other pictures, I could have been wrong. Lying, perjury, no, come on. Just vantage point, just perspective. And then that's why you're here, because you get to figure it out. Rachel Gentile. Let me give you my perspective on Rachel Gentile. She didn't want to be involved in the case. She didn't want to be involved in the depositions. She didn't want to be involved in the trial. I think what happened, and this is just conjecture, and I'm not supposed to conjecture too much. I think her mom got with Miss Fulton and said, go tell that lady what happened to her son. And she didn't really want to do that. Why she wrote the letters. Why she had or didn't have a conversation. Don't forget, they had only reunited Trayvon Martin and Rachel Gentile like 2 weeks before. Phone records are in, you know that. They knew each other from school, but never really hung out. 2 or 3 weeks before was when they started talking again. So it wasn't what it was perceived to be as girlfriend, boyfriend. It had nothing to do with that. And she just didn't think it was much that night. Interesting to me, just the one thing about Ms. Gentile, if you ask me right now to explain to me the phone call that I had 3 weeks ago with my wife, 4 weeks ago with my sister, or last week with Mr. West, I can give you the idea, and then my wife would say, well, we talked about dinner. Oh, no way do you have the recall. But if you're asked to have the recall, tell me what happened. This happened. Did this happen? Didn't you say this? Didn't you say that? Well, he didn't say, what are you talking about? He said, what are you doing here, right? Oh, yeah. You want that too? Yeah. She didn't want to be here. And I don't want to sound like I'm asking Cynthia. I'm sorry that she had to involve her life in our life in a way that she never wanted to be involved. Unfortunately, she was a witness, and we had to deal with it. And some of her frailties came out in the courtroom on TV, and I'm sure she never wanted out. And probably every other thing. Witnesses wanted to be anonymous, that they were concerned, and she wanted. Some of the stuff she said was, that it was close to the dad's fiance's place. I actually think probably she meant close as compared to the 7-Eleven. Makes more sense. It took him 45 minutes to go from the 7-Eleven home. Probably was just hanging out at some mailbox. I'll show the map between the two. Doesn't make any sense if you were hanging out in the mailbox at the 3-feet circle, but whatever. And heard, why you following me for? Somebody said, what are you talking about? Then it changed. I think that change occurred because of the way her initial interview was handled by one of the attorneys. Horribly inappropriate to not get this person to law enforcement. Almost as bad as to have the mom on the couch next to you crying when the state does their first interview with you. Their call, but wow, to do it that way. Of course, she even acknowledged that she was concerned about Miss Martin's feelings, which is why she sort of modified or smoothed over some more colorful language in the events that happened. It's okay. You're supposed to just tell the absolute truth here, but I'm not going to ask someone like Ms. Gentile to come in and just not acknowledge the sensitivities of why she may have made it sound a bit better when telling the story of her son's passing to Ms. Fulton. Ms. McDonald, T-Mobile Records. Ms. Lauer. Interesting about her because she sort of, without knowing about it, she gave you some pretty good information when she talked about this 3-part exchange. But she was who said it before she had any idea about it actually happening. And what she said was, yeah, somebody said something, blue car, red car, blue car, blue car, red car, blue car, and yeah, something like that, a little agitated, and then movement down. That's where we got the movement down in the animation, by the way. She said T intersection down to the past me, and then of course John Good says it happened in front. And but there's only one person yelling help. That's significant because there is no evidence, none, to suggest there was more than one person yelling for help. And if so, Mr. Guy will remind you of it if I've forgotten. No evidence that more than one person was yelling for help. And she was talking about her knowledge or lack of knowledge about the street signs. Ms. Moore, we talked about, she heard what she heard, and then she saw what she saw. By the time she saw it and ran around, that's what happened. Greg McKinney, reckless custodian, John Good, we've talked about him a lot. I think he's a significant significant witness because he watched it for 8 to 10 seconds, and he was the basis for the animation, making creepy through the animation. Manalo, Jonathan Manalo, same thing. Looks like he's got his butt beat and staggering to the ground. Ricardo Ayala, SPD, the hands under the body. You know, if that is a concern of yours, that my client dared to testify in a statement that he took his hands out out of fear for a weapon, and that is contraindicated because Trayvon Martin's hands, look at the picture, by the way, one hand's not really under him, but the other hand seems to be, that is some inconsistency for which you should impute ill will or hatred or spite. That's absurd. And DeMaio, Dr. DeMaio said it was 10 to 15 seconds of talking or movement or whatever. Not only is it possible, it's probable. Stacey Livingston, EMT who was there, you heard all about the injuries and what she did. Timothy Smith, important because, if you remember him, he was the first one on the scene, took George Zimmerman into custody for his own protection. He was the one who George Zimmerman talked to twice about screening for help before he knew that there was any 911 call suggesting it. Lindsay Folgate, you know about the medical records, and she was the first one to mention MMA style. Hirataki Nakasone, you know about him, basically said, can't tell you, can't help you, don't do it, don't even try. Fortunately, even the FBI couldn't help us out with that voice. So now it is sort of up to you on that. Doris Singleton, initial activity with him with the interview. And I think what was significant about that was George Zimmerman's response to the Christian issue and to the fact that she was the first person to tell him that Trayvon Martin had passed away. And the statements are what the statements are. Chris Serino, again, he stated was, in his opinion, and again, he's the law enforcement officer in charge of the investigation, that there weren't any significant inconsistencies in what he heard from George Zimmerman. Were there some? Yes. Were they significant in his mind as to what, that they were lies? No, not even when he did the challenge interview. Let's talk about that challenge interview for a second. The state said to you, George Zimmerman knew those video cameras weren't working. So, it wasn't a bluff. It was, again, a super cop knowing everything and just deciding, I can get away with this. Really? Really? So when Chris Serino,
really
seems to be a problem with this, I'm going to look at it for a second. Chris Serino said, I lost my train. I'm going to catch up in a second here. What he had said was the inconsistencies did not matter to him and did not change his opinion. And when the confrontation interview occurred, and when George Zimmerman said, thank God there may be a videotape. The state wants you to believe the perfect super cop bluff response because he knows this, because let's not forget, he took a couple of classes a couple of years ago at a community college. Absurd. I would suggest to you, to make a suggestion to you, that in that moment, when confronted with the potential of an actual video by Mr. Martin, that my client would do anything other than say, thank God it may be there, and that's not evidence of innocence. Mark Osterman, good buddy, don't think he would lie for his friend, but was the one who testified about self-defense, and I think you remember his testimony, a little bit animated, but sort of told you all about everything he could about both George Zimmerman that night. They wrote a book about it, that his story is a little bit different from George's other stories. Figure it out, and figure out how significant it is, and whether or not it suggests second degree or anything. Now, Dr. Rao, I don't know what to say. Minimum of 4 hits. Okay. You see the pictures. If you think George Zimmerman was only hit 4 times, fine. Let's take a moment on those 4 hits. You're going to get the statute, you're going to get the jury instructions. Here's what they're going to tell you about the extent of the injuries that you have to find my client suffered at the time he decided to shoot. The significance of those injuries how life-threatening those injuries were, how soon my client presumed he was going to die from the injuries that were already inflicted upon him. Are you ready? 0. 0. No injuries necessary to respond with deadly force. Not a cut on a finger. The statute is clear. Reasonable fear of bodily harm. Captain Carter told you, whoa, you can get reasonable fear of bodily harm when you're already getting your butt beat. That's certainly an indication. But do you need a cut on your finger? No. Of course, getting a cut on your finger doesn't allow you to just shoot somebody unless you're in reasonable fear of ongoing great bodily injury. So the injuries, icing on the cake of self-defense, has nothing to do with the substance of self-defense. Not a thing. You will not hear a word about inflicted injuries. You only hear that you must look at George Zimmerman's state of mind when he did what he did. So even if I said to you, I'll take Dr. Rao's testimony, though you can tell I wasn't taking it. But let's just say I was. Doesn't matter. Ms. Benson, print expert, there wasn't a lot. Absence of prints doesn't mean no fingerprints or no touching, just that it's not there. Environmental factors such as rain could remove them. Lieutenant Scott Kieran's, the application that was denied because my client, Mr. Zimmerman, didn't have good credit. Captain Carter, criminal litigation coursework. He actually turned out to be a good expert to tell you what self-defense is and how getting your butt beat is really probably a good indication that great bodily injury is coming because it's already started. And he says, not a good idea to wait until it actually, you get attacked. Jim Krasinski, records custodian. Gordon Pleasance, we talked about it, taught the course online to Mr. Zimmerman. Amy Seward, firearms. She mentioned the full round of bullets, full complement of bullets. And I think we had good testimony about that. Anthony Gargone, FDLE, talking about DNA. You know, the problem with part of that DNA, they got some. I think they missed a bunch, or at least some because of the latest factors. Significant? I don't know. I don't think it was that significant. There may have been more blood. I don't think that George Zimmerman was bleeding a lot that night. I don't think he was bleeding a lot out that night. I think he was probably bleeding a fair amount in. And then when he stood up after the attack was over, yes, it started coming out of his nose. Not a lot of blood on Trayvon Martin. Probably not a lot to be expected. And there was no injuries on Trayvon Martin to the gunshots. So you wouldn't imagine there would be any blood on George, George Zimmerman's hands, or any place else in his body, because when Trayvon Martin was finally shot, he went up and over. So DNA, we can go over some particulars about it, and I have some precise points about what was found on Mr. Trayvon Martin's cuffs and whatnot, but generally speaking, not a lot significant. Ms. Fulton, people ask why I even questioned her. How dare you question the mom of a passed away 17-year-old? Doctors cut people sometimes when they do their work, and that was something that I had to present to you. Do something about the way it happened and how it happened, and you know, the impact and just how moms think about these things, both sides. Because I know that both moms believe with their heart, with their soul, that that was their son screaming for help. You have to, and you want to, and it's just the way you get through it. DeVar Fulton, his brother, he really didn't know. I think he told you in his testimony when he was talking to the NBC affiliate. You know, it could have been him, not certain, might have been. And now he's more certain. Oh yeah, I'm okay with that. I'm okay with people wanting to hear what they want to hear. Mr. Bao, Dr. Bao, that was the state's decision to bring him before you as a medical examiner. Really, that's their decision. He was the one who did the autopsy. So, although there was some interaction there that might have best been just redone, reality is the only injuries were the injuries that we know about on Trayvon Martin, and that the wet clothes should not have been bagged in paper, and that the hands should have been bagged. And we'll talk about the hands in a little bit. Ms. Zimmerman told you that it was her son, as I'm sure you expected before she ever got on the stand. Corte Mesa, interesting, because that was unplanned by him, it would seem, if you believe his testimony, sitting at a computer listening and then hearing in the background a voice that he knew without question, and immediately to be that of his nephew, George Zimmerman. I think he came across very credibly. I think he came across a man of his oath and of his word, and I would ask you to consider the testimony in that regard. Mark Osterman, buddy of his, talked about the weapon use, how you holster a gun. Yeah. He's good at what he does. He was helping George figure out how to fire a gun. Sandra Osterman, friend, definitely George Zimmerman, screaming for help, and explained away some of what the state was trying to prove to you through the non-emergency call about the anger and hatred and all that just isn't there. Same thing with Miss Jerry Russo, no question in her mind, George's voice. Same thing with Leanne Benjamin. Has heard him scream and yell at campaigns, and that was George Zimmerman. John Donner was interesting because I'm not sure that I could, if I had thought about trying to figure out who in the world talks to people they know and then hears them scream for their life. I just, there's no profession that does that. Maybe a cornerman in a boxing ring, but they don't scream for help there. A medic in Vietnam, a person who hangs out during the day with his buddies of 60 to 100 people, figures out who they are, what they are, who they left behind at home, when they want to go back, when they might go back, and when, you know what, that they might never go back. Because he's the guy who grabs a medic bag and the rifle, I think he said, and heads out towards the screens. And that even before he gets there, sometimes, he knows who it is who's screaming. Wow. Didn't want to testify. I don't think the guy who's been in Vietnam wants to come before people and break down a little bit. But I think that his testimony was quite credible when he believed it was Mr. Zimmerman. George Singleton and, by the way, Chris Serino both say the same thing. Unfortunately, when Mr. Martin did first hear the tape, he said what he believed to be true then, it would seem from the officers, and that is, that's not my son's voice. It just wasn't his voice to him, and his mind has changed now. But it is interesting for you to consider when you're trying to figure out that issue of who said what and what witnesses said what, because you're going to give them credibility, you're going to weigh them, you're going to decide to dismiss their testimony or to accept their testimony, and try and figure out, remembering always, as we'll talk about in a moment, the benefit always goes, or the doubt always goes to my client's benefit. And Pollock, animated, good guy. George is soft. He's a 1. I don't care that he's been here for a year. I'm not sure I would have actually advertised that I trained George Zimmerman for a year and brought him from a 0.5 to a 1, but he did. Now the fighter, and I got off a bag. So this MMA, you know, George, I think the statement said it was 18 months. And George is MMA training, 3 days a week. Really? Come on. Really? In light of the testimony of the trainer who said I wouldn't even let him do anything but shadow box, the shadow might win, and hit a bag.
For fear that the shadow might win.
Chief Bill Lee, he was there for the whole part of it, but most importantly, he was the officer who said, whatever you do, separate them. Don't infect witness testimony with other witness testimony. It is top 101.
The shadow might win.
I understand the sensitivities of them being family members listening to the possible voice of their son and definitely the gunshot that ended their son's life, but law enforcement, ongoing investigation, just put them in one at a time. The way it was handled infected the evaluation of that testimony horribly. And who gets the benefit of that? George Zimmerman. Vincent DeMaio, just a grandfather. He's done this his whole life. Came in and gave me some really good information about everything having to do with gunshots. Really good because he failed and refused to go beyond gunshots, even when I think we tried to take him a little bit. And he said no. And then the state tried to take him a little bit. He said no. I'm good at what I'm good at, but I'm only going to talk about what I'm good at. And what he's good at is gunshot wounds, and suggesting that it made perfect sense.
He was
that
good. I liked him. He was a nice.
Would do what it did. Does it make anything less than perfect sense as to what happened? It's in there, and he's leaning over. And his loose, billowing shirt falls forward. And he gets shot. And it's contact to the fabric. It is not pressed against the chest. I think that little play in opening statement has been dismissed. And it was 4 inches from his chest. As it turns out, the type of forensic evidence is fairly significant because it completely supports the contention that Mr. Zimmerman was on the bottom, Trayvon Martin leaning over the top when he got shot. Now, here's a theory of guilt for you. You ready? Because this is the state's presentation, so listen carefully. He might have been backing up. He could have been backing up. Could have been. If I was arguing that, I would be arguing to you reasonable doubt. You know, it could have happened this way. It could have been that he was backing up. Well, I don't know. I almost made light of it when I said, well, he could have been backing up and striking another blow. But the could have beens don't belong in this courtroom. Proof beyond a reasonable doubt. Consistent with a reasonable hypothesis of innocence, he was leaning over him. Nothing to suggest anything else but that. He could have been leaning back at some point after 45 seconds of attacking George Zimmerman for no other reason. Let's not forget, he didn't back up when John Good told him to, right? So for some reason, just before the shot takes off, at that moment, the state wants you to believe Trayvon Martin retreated. Really? Really? One piece of evidence, just one I asked for, just one piece of evidence that supports that contention. Where is it? Where's the eyewitness who said, I saw him back up? Where's the forensic evidence? Where he got all the way back up, chest and shirt are tied together and shot is through and through. Where's that piece of evidence? Where's one shred of evidence to support the absurdity that they're trying to have you buy? One. Mr. Guy can tell you about it when he closes, if it's there. Assumption, supposition, could have been. Thrown apart. Just part of the absurdity of how this thing happened with the phone call, with the tape. I don't think it matters too much. Miss Delegard, nice lady, didn't want to bring her here sick. Knows George Zimmerman, saw him that night, saw him beat up, saw the picture, or hit, I'm sorry, saw him hit. And then he has a light voice, and it sounded like it was his voice. Dennis Root, you know, it's interesting. Again, talk about the Bizarro case. Now we have prosecutors attacking, sort of impeaching, lifetime law enforcement officers who have dedicated their life to the pursuit of perfection in law enforcement. Perfection. My God, he's trained in everything. He takes something on, he becomes a trainer. And now we have the state impeaching. Well, hold on a second here. Could have been this way, right? Not really. Well, let me ask you this question, as the guy says. At that moment, what other options did he have? None. He had none. From a use of force expert who's been doing this his entire career and who has become proficient in assisting others in learning how to use force, learning how not to use force, learning when to use force. And they asked him the question of whether or not George Zimmerman had alternatives. Tell me the piece of evidence that contraindicates that. Just give me one. Give me a shred of evidence that contradicts that he had any other option. Because now we have an expert who's qualified, who gave you that opinion. Dismiss it if you want. The judge will tell you, just because you're expert doesn't mean it's gospel, that you have to listen to them. But if you believe them, if you think you're well qualified to give an opinion, if it's an area of inquiry which will help you, then accept it. Ms. Bertolon, I hope it does not come across that I was just seeking sympathy for this woman. But the reality is, I think when you put a face on what was happening at Retreat View, she's it. She really is.
Her story.
Just, thank God nobody came upstairs.
Sad.
I'm not sure the scissors would have really helped.
Jesus.
But that's the face. And I'll tell you this, I'll give you this much. That's the face of the frustration that I think George was feeling a little bit of. You know, that's something that he wanted to help out with. That's why he walked over and didn't say, I'm going to go pick the fight. No. That's why he said, here's a lock for the back of your door. Here's my telephone number. And here's my wife's number. You need our help? This is what we do. We help. Dad, you know, he said it early. You got to give it this much. He said it right away. He went down to SPD to talk to them, Sanford Police Department. They put him under oath, or maybe the state police officer. Put him under oath and said, okay, now, you're under oath. You got to tell the truth. Is that your son? Yes. We talk about a few other points, if I might. Oops.
Oops.
Because this is not working. It might come back. If not, I'll just read it to you.
Are you going to
Is there a chance it'll come back up? That'd be great. If not, I'll just work without it.
Junior quote, a rendition of a quote.
Some of the things you want to consider when you look at this case is the forensic evidence, what it does and doesn't support. Here was an interesting thing that I didn't make a big deal about in the trial, but I want you to focus on, because a lot has been said about the lack of blood and what happened to the blood. And well, if Trayvon Martin was doing what George Zimmerman says Trayvon Martin was doing, where's the blood? Where's the anger? Where's the show up on the hands? State 28. Gunshot wound. See the blood trickling down across the chest? See that 3-inch swath of blood all the way over there? It's 895. It's gone. Not there. Yet, everybody who handled that body said they didn't touch it or they didn't wipe it. They may say, well, that was when we moved the sweatshirt up and moved it back down and the blood is all gone. But let's not forget, the blood was there after they moved the sweatshirt up. So why wasn't it there if they moved the blood down? And it was actually still losing in this photograph. So, some big moment. I proved my case? No. But the idea that they want you to assume, that they want you to believe, just connect the dots, that there was no blood because there was no blood when they failed to properly preserve items like the sweatshirts, items like the body, it seems, items like the hands that were to be bagged but weren't. They don't have to prove beyond a reasonable doubt that they bagged the hands. That's not an element they have to prove. But if they're going to try and come up with conclusive evidence that supports no other reasonable hypothesis of innocence but guilt, then they have to have a better case. And this is just some evidence of it. So let's talk about other things you have to consider about that event. A couple of graphics. George Zimmerman, the way he was. Trayvon Martin, the way he was. And I'll do other sides.
Oh, look in there. I think that's clever.
Trayvon Martin. Some gray shoes I have to show you. He has a hoodie on. Top of the hoodie. This is from the picture that we showed you. It's not an evidence. Just to have you look at it. Don't even have to believe it's accurate. Take a look at it. Remember how much taller I was than Andrew Goff when I was standing next to him, and he testified that he was 5'10". Then there's George Zimmerman and how tall he is. Take a look at him compared to my eye height.
I like that demonstrative tip.
Relative physical abilities. That's what you have to look at to determine in a self-defense case. So you look at this guy that night. Don't look at him today. There's been testimony all over the place as to how much weight he gained. It doesn't really matter. What matters is how he looked that day and how Trayvon Martin looked that day. The other thing that's in evidence, just so you get a clue, or not a clue, an indication. November 15th, 2011, about 2 months, 3 months before Trayvon Martin passed away. That's what he looked like. He's a young kid. Nice kid, actually. If you look at the picture, not bad. The problem with it is that when we show you autopsy photographs, there's two things you need to know about autopsy photographs. One, they're horrific, and they're meant to have negative impact. I did it when I was a prosecutor, prosecutors all the time. A dead person on a slab has an impact on you. I would say that maybe one of you, maybe, have looked at a picture like that before this trial. Maybe one. It has an impact. The other thing about autopsy photographs is that there's no muscle to them because there's no nerves, there's no movement. He lost half his blood. We know that. So on that picture that we have of him on the medical examiner's table, yeah, he does look emaciated. But here's him 3 months before that night. So it's in evidence. Take a look at it. Because this is the person, and this is the person who George Zimmerman encountered that night. This is the person who, all of the evidence, was attacked, or attacked George Zimmerman, broke his nose or something close to it, and battered him on something. The state now may say, oh, maybe it was just a drain box, and it was no intent to hurt there by Trayvon Martin because it was just coincidence that he was bashing his head on something hard and it was a drain box. Really? Come on. Really? Those injuries?
I don't have.
You know how dark it was out that night? You've seen this before. It was out of this darkness that Trayvon Martin decided to stalk, I guess, plan, pounce. I don't know. All I know is that when George Zimmerman was walking back to his car, out of the darkness, be it bushes or darkness or left or behind or somewhere, Trayvon Martin came towards George Zimmerman. Out of this. And we know what happened. The big picture is what happened. And it's supported by evidence. You know, I talked a moment ago about ignoring George's statements. You know what? Don't ignore them. Listen to him. Find the inconsistencies in them. See what you think about him. Take him in context of what he was going through that night and how voluntary he gave all of those statements, and decide whether or not, as Dennis Root said, as Chris Areno said, as I believe Singleton said, if anyone is giving me the same exact story twice, they're probably lying. They're probably pathological liars. Because when you lie, I guess, since you're making up a fantasy, you can tell the fantasy twice, the same exact way. But you get your nose smashed, your head smashed, and trying to do what you can, and you answering every question they ask of you, then yeah, okay, deal with the inconsistencies however you want to. But maybe I would suggest you begin by dealing with them the way Chris Areno did, since it was his case. And what he said to you was, yeah, there's inconsistencies. He said I got hit 25 times. Nah, I don't believe it. It seems he didn't get hit 25 times. Did it feel like he was getting hit 25 times? Maybe. Is that the embellishment, the exaggeration the state is talking about when they say to you, oh, he's exaggerating, he's a liar? He's a liar? Really? Come on. Those are lies. If you lie, it's normally with intent to deceive, isn't it? Isn't that the essence of a lie? If George Zimmerman had the intent to deceive, why would he give 6 statements? If you're going to give him credit for anything about going to school and going through legal studies, here's one, Miranda. He knows self-defense. He knows stand your ground. He knows whatever the state wants you to think he knows, but he doesn't know Miranda. Oh, no. He knows Miranda, but he was such the mastermind that he could, without knowing any of the evidence, who was watching, who was videotaping, who was doing anything, without knowing any of that, he had it all sussed. He had it all figured out, really. It defies explanation. It doesn't defy explanation of things like this. The mud on the knees, evidencing the mounting. What doesn't defy explanation is Officer Tim Smith's testimony that George Zimmerman's back was wet, more wet than the front, and then he had grass all over his back, evidencing, I would opine, that he was on his back in the grass. And he was getting beat up. Manalo, Tim Smith, Wagner, everybody else who saw those injuries. Okay. You don't get it correctly, but you do still get me going over some of the instructions with you. Reasonable doubt. What is it? Can't tell you any more than we have. The judge has read to you a couple of times already. You're going to get it again. Reasonable doubt. Don't start with the premise. Presumption of innocence sticks and stays until it is taken away by evidence that convinces you beyond a reasonable doubt that it is no longer appropriate to consider Mrs. Zimmerman innocent. Then and only then do you get to convict my client anything. A reasonable doubt is not a mere possible doubt. If you got to make it up, that's not a reasonable doubt. We talked about me proving my case as though I had to. It's not a speculative doubt or an imaginary doubt or a forced doubt. If you have a doubt and you say to yourself, I don't buy this doubt, I'm going to force myself to believe it, that would be a forced doubt and isn't reasonable. But a reasonable doubt is not a mere possible doubt, speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty. If you have an abiding conviction of guilt, on the other hand, and this is the meat of it, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or having that conviction, it is one which is not stable, one which wavers and vacillates. Then the charge is not proved beyond a reasonable doubt, every reasonable doubt, then you must find George Zimmerman not guilty because the doubt is reasonable. I almost wish, and I've never said this in a criminal trial before, I never heard it being said before, I almost wish that the verdict had guilty, not guilty, and completely innocent. Because I would ask you to check for that one. You got to check the not guilty. But check the innocent then too. A reasonable doubt as to George Zimmerman's innocence may arise from the evidence, conflict in the evidence, or a lack of evidence. If you have a reasonable doubt, you should find George Zimmerman not guilty. If you have no reasonable doubt, you should find George Zimmerman guilty. Weighing the evidence, you'll have all this before Judge Nelson's going to read it to you. She's going to give it to you. But just to focus on what you do about these witnesses, the question is whether or not they had the opportunity to see and know the things they're telling you about, obviously. That's that vantage point concern, how they really can look at it. Perception you have to see. For example, somebody came in, wasted off their mind, then give them less credibility. We won't have that here, but you got to look at it and decide whether or not they had an opportunity to see what they're talking about. Do they have an accurate memory? And we know that memory is affected by traumatic events. I think Ms. Sodika is a good example of that. She was frantic about what she perceived was happening outside. And I think it may well have impacted on her ability to recall, not calling her anything but a person affected by the circumstances. Were they honest and straightforward? I would put up on that pedestal Ms. Bahador. Your call, but as whether or not she presented in a way that made some sense. If you heard of Ms. Moore, who just seemed to be saying what's remembered and very willing to show you. Did they have an interest in the outcome? Well, let me tell you something. When George Zimmerman gave those statements to law enforcement, he didn't know it, I don't think. Didn't seem normal that he would have ever been charged in this case, but in his mind at that time, I presume you could say that he had an interest in telling the story as good he could for himself. So, sure. Was there an interest in the outcome? Absolutely. These people going to take away his liberty? Absolutely. Consider that when you look at those statements as well. And
he's falling
does
asleep.
His testimony agree with other testimony? That's the global.
I mean, I'm falling asleep too,
That's
but
what I'm
damn,
saying to
that's
you.
not
When you
my
look at it in
son's
totality of the
trial.
circumstances, don't just give me one sheet and go, well, what do you think now?
So is he.
That's that totality of the circumstances.
Both daddies are falling asleep.
Rules for you to deliberate under, and here they are. The case must be decided upon the evidence, so it makes sense.
No, thank
That was
you.
the
Okay.
A person is justified in using deadly force likely to cause death, if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself. There are alternatives, death or great bodily harm. So I'm going to go through this and tell you that what you need to consider is whether or not George reasonably believed, reasonable fear of great bodily harm. He doesn't have to think he was going to die. He does not have to think he was going to die. He does have to think that he was going to be injured greatly. And since the alternative, if either matches, it's been met. In deciding whether or not George Zimmerman was justified in using deadly force, you must judge him by the circumstances which he was surrounded with at the time the force was used. The moment of using the force, what was happening?
Force.
The danger facing George Zimmerman need not have been actual. Now, getting beat up sort of takes that better in context, but it doesn't have to be actual.
Puppy.
In effect, I guess, the knife coming at you could be rubber, as long as you perceive it to be steel. Or the next blow of a fist could be a fake one. But as long as you perceive it to continue to be blow down upon you, then that's enough. The danger that George Zimmerman faced need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person, under those circumstances, reasonably prudent and cautious person under those circumstances, put yourself in effect in the mind of what George Zimmerman was going through, the circumstances that he was going through, and then decide yourself whether or not that a reasonably and cautious person under those circumstances would have believed the danger could only be avoided through the use of that force. That applies in this case. Every shred of law that applies to this case, you will have before you. What you won't have is any law that suggests something like following somebody is illegal, because it's not. Following somebody in the car or foot in order to report their whereabouts to the police is not unlawful activity under Florida law. If it was, you would be instructed on it. You would have a statute as part of your jury instructions that says something that George Zimmerman did was unlawful. And you wouldn't have it because it's just not there, because it's just not true.
It's lawful law, y'all.
I'm over my time. I'm going to finish up quicker than I would like to. I cannot imagine that I've actually been here for 3 hours, but I want to do a couple of quick things to show you, since this is the state's burden, what they haven't proven about it. I don't think it's a big deal if they decide not to give you the 6th emergency or non-emergency call. I just, they should have, just to be complete. Or whatever. I don't know, the fact that I had to call Tracy Martin to have him testify to that when it's the state's case, I guess that they didn't have to do that. But if you're really seeking justice, why have me do it? Why not even have Serena testify? Why did I have to have him testify that Tracy Martin said it wasn't his son? Why did I have to have Singleton testify? Certainly they're available to me, and I did it. And I guess if I can do it, the state doesn't have to, except, it really and always will be their burden, not mine. They didn't tell you about all the other burglaries that happened at Retreat View. I did. They're there. I haven't highlighted them, but trust me, they're there. Where's the expert countering use of force? Where's their guy? So all we have on use of force now is Dennis Root. Again, they don't have to bring a use of force expert. I did it. They don't have to. But if that's their issue, where's their information? Same thing with Dr. DeMaio. I guess they sort of had Dr. Round. Well, no, not on gunshot. But where's that? Again, they don't have to, but this is their case. I mean, it affects George Zimmerman, but it's their prosecution. It's their burden. That he pushed the gun into Trayvon Martin's chest. Justice and emotions, you got to be careful with it, because we all have emotions as human beings, and then we have justice. And you sit back and you go, what are they trying to do? Does it really help you decide this case when somebody who is not George Zimmerman's voice screams at you or yells at you and curses at you? No, I would contend. Listen to the tape. Don't listen to Mr. Guy. I'm sure people say that I look like Joel Osteen, and I think Mr. Guy is trying to sound like him with this really small effing hunks. Do we need that? I do a little bit, I guess. But do we need that type of anger coming out from a prosecutor rather than from a defendant? Is that really the way we're going to present this case to a jury of?
Well, what happened?
One piece of evidence that my client attacked Trayvon Martin, landed one below, for that matter, did anything to justify in any form or fashion the onslaught of injury perpetrated upon him by no one other than Trayvon Martin. He actually had something else, because George Zimmerman was, in fact, armed with a firearm, and we know that. We know he had the right to have it. And then it was said, how many times was it said?
Oh, dear.
Trayvon Martin was armed. Now, I'll be held in contempt if I drop this, so I'm not going to do some drama and drop it on the floor and watch it roll around. But that's cement. That is a sidewalk. And that is not an unarmed teenager with nothing but Skittles trying to get home. That was somebody who used the availability of dangerous items from his fist to the concrete to cause great bodily injury. Not that it's necessary for self-defense, but great bodily injury against George Zimmerman. And the suggestion by the state that that's not a weapon, that can't hurt somebody, that can't cause great bodily injury is disgusting.
All right.
Even if we presume Rachel Gentile was completely accurate in whichever version of what she first heard happen you want to believe, what she said was that George Zimmerman said, "What are you doing around here?" Let's just for a moment presume that we had that on audio tape. Let's just say they were recording their phone call and you heard her voice. Oh, you heard George Zimmerman's voice on the tape that said, "What are you doing around here?"
It's not illegal.
What did Mr. Root say about that? What did the only expert that talks about the evolution of force tell us? Well, you say something like that, I might say, "Whatever I want," or "Who you to ask," or "What do you mean?" or "Get out of my face." But Dennis Root didn't say that the appropriate response is to break somebody's nose. Did he? Did he suggest that that was even near the spectrum of violence allowed, or the spectrum of force allowed in a situation like that? Unfortunately, there was some anger and hostility and ill will and spite maybe that night. It just had nothing to do with George Zimmerman. Well, that's not true. It had something to do with George Zimmerman. He was a victim of it. Because you can't look at those pictures and say that what was visited upon George Zimmerman was not evidence of ill will, spite, and hatred. Had Trayvon Martin been shot through the hip and survived, what do you think he would have been charged with? Aggravated battery, 2 counts? The state has to convince you beyond a reasonable doubt. You have no doubt in your mind that my client is guilty of anything. You get trial hypnosis. You think that you say the right things whenever you talk as a lawyer. So within that context, I really feel like I may have convinced you beyond a reasonable doubt that Mrs. Zimmerman is innocent. But of course, we know that has nothing to do with it. The state will get up and finish in just a couple of minutes, and they will tell you he's a liar again. Maybe not, because Mr. Deliano spent most of his time convincing you that my client lied. But here's the standard. You go back there. First thing you might want to consider doing. You have a reasonable doubt that my client may have acted in self-defense. Go back there and say to yourselves, let's just forget the crimes. Let's just talk about self-defense. Do we think he might have acted in self-defense? Not convinced. I have some doubt, I have some concern that he just may have acted in self-defense. And if you reach that conclusion, you get to stop. You really do. Why? Because self-defense is a defense to everything. To littering, to speeding, to battery, if it mattered, to grand theft, to assault, to manslaughter, to second degree. You go no further than a determination that the state, now that we're done and there is no more evidence, that the state has not convinced you beyond a reasonable doubt that George Zimmerman did not act in self-defense. It's an easy decision. And I don't say that out of hubris or just ego. Ha ha ha. I'm saying it because of the facts of the case.
Ha ha ha.
You look at these facts, you look at all this evidence, and you have to say, I have a reasonable doubt as to whether or not the state convinced me he didn't act in self-defense. That's all you have to do. You don't have to write innocent on the bottom of the verdict form. We don't go anywhere near those in this courtroom. The state never, ever loses their responsibility to take away reasonable doubt from you. Don't let them do it in a window. Don't let them do it with sympathy. Don't let them do it with yelling. Don't let them do it with screeching, because none of that matters. Because we have a definition of reasonable doubt, and now you do. You look at that definition, you go back to that room and say, let's talk first about self-defense. If I think George may have acted in self-defense, we are done. So, thank you for the time. Thank you for the attention. Again, we talked about it way at the beginning, an amazingly difficult task that we've asked you to take on. And we often had jurors a couple of whom we had to wake up on occasion. You're certainly not those. The note-taking, the interest, it's been apparent. I appreciate the time. My client does, the state does, I'm sure the court does, and Seminole County does, because you've given us what we needed from you, which is your attention. I want one more thing from you. I want you to really, really look at those instructions, apply them, and just say he acted in self-defense, find him not guilty, let him go back and get back to his life. Thanks.
Thank you, Mr. Romero. Ladies and gentlemen, do you want a brief break before?
Yes. All right. So now I have to figure out if I can find the state's rebuttal, because it turns out it was not on there. So let me see what I can find. Let me see what I can find. Ow. Doggy, you're hurting me. You're hurting me. Okay. I found something. I found it. I found it. I'm gonna stop this one. You can get down, puppy. But you're not gonna. You're just moving. You're just readjusting. That's fine. Okay. This one's weird. Now I've not seen this one at all. So I have no idea what this one is gonna be like. So up next, just the state's rebuttal, and then it's done and it goes to the jury.
Every day, at any moment in the day. It has a great many. Councilman, good afternoon. The human heart, it has a great many functions, but is not the most important purpose what it causes us to do. It moves us, it motivates, it inspires us, it leads us, and it guides us, our hearts, in big things, like what we choose to do for a living, and in little things, like what we do every day, at any moment in the day.
Sounds like a preacher.
So if we really want to know what happened out there behind those homes on that dark, rainy night,
oh dear God,
should we not look into the heart of the grown man and the heart of that child? What will that tell us about what really happened out there?
So the first one was yelling, and this one sounds condescending.
That's what was in George Zimmerman's heart. And the defense attorney can make fun of the way I say it, but it's not my voice that matters. It's yours. And we're about to hear from you. What does that say to you? Was he just casually referring to a perfect stranger by saying effing punks? That doesn't evidence to you anything? That's normal language? Or is that not what was in that defendant's heart when he approached Trayvon Martin? What does that tell you? It's funny. He put on a timeline that was 10 feet long. And the only thing he skipped was those two words at the bottom of the screen. It's the only thing. Think there was a reason for that? Think there's a reason he didn't want you to think about that again? How powerful that is? What that defendant was really feeling just moments before he pulled the trigger? Think that was a coincidence? What was in Trayvon Martin's heart?
Well, nothing new.
Was it not fear that Ms. Chantel told you about? The witness who didn't want to be here, the witness who didn't want to be involved, but the witness, the human being that was on the phone with the real victim in this case, Trayvon Martin, right up until the time of his death. Was that child not in fear when he was running from that defendant? Isn't that every child's worst nightmare?
Nothing.
To be followed on the way home in the dark by a stranger? Isn't that every child's worst fear? That was Trayvon Martin's last emotion. There's a old saying, great one though. As a man speaks, so is he. The words on the screen
Creepy ass
were the last
cracker.
thing these people said
Creepy ass cracker.
before Trayvon Martin was murdered.
Fucking pump.
Before this defendant had a motivation to lie, to justify his actions. What were his words? What was in his heart?
Both seem kind of insulting to me.
If ever, there was a window into a man's soul, it was the words from that defendant's mouth on that phone call.
Oh,
And if ever there was a
fucking
question
God.
about
Are you kidding
who
me?
initiated the contact between that grown man and that child, it was again those defendants' words. When he told Sean Nofke, just have the officer call me on my cell phone, and I'll tell him where I am. George Zimmerman was not going back to the car, or the clubhouse, or the mailboxes.
Oh, where was he going?
And if there was ever
Mr. Guy, please tell
any
me where he was
doubt
going.
about what happened, really happened, was it not completely removed by what the defendant said afterwards?
What'd he say?
All of the lies he told, all of them.
All of
What does that tell you?
Are
There's
you a
only
preacher?
2 people on this earth who know what really happened. And one of them can't testify,
Oh no.
and the other one lied.
Oh
Not
my
about little
God.
things like his age, or whether or not he went to the hospital, but about the things that really, truly matter. And not one lie, over and over and over again.
Over.
What does that
Over.
tell you about what
Over
really
again.
happened out there? Why did he have to lie
Why?
if he had done
Oh
nothing?
my God.
The bottom
So
line
fucking
is, the
true.
bottom line. Think about this. If that
I wonder
defendant
if people realize how
had
stupid
done
they sound when
only
they're doing
what he
this
was
shit.
supposed to do, see and call, none of us would be here. None of us. But that's not who he was. That's not where he was that night in his heart.
Why do you
After
sound like
months
that? You haven't sounded like this the whole
of these
fucking
people
time.
getting away. Not tonight. Not this one. Not that guy. That's why he got out of the car. If he really wanted the police to get Trayvon Martin, what would he have done? He would have stayed in his car and driven to the back gate where he had told them so many times they always go through the back gate. And he would have waited for the police. But that's not what he had in his heart.
Don't speculate. You don't know what the fuck he had in his
Trayvon
heart.
Martin may not have the defendant's blood on his hands, but George Zimmerman will forever have Trayvon Martin's blood on his. Forever.
Forever. Say it again. Forever will
Let me give you
forever
one
have
more
his.
thing. Maybe the most important one you're going to hear. And that is, to the living, we owe respect. But to the dead, we owe the truth. On behalf of the state of Florida, I submit to you that Trayvon Benjamin Martin is entitled to the truth. And it didn't come from that defendant's mouth. It didn't. He told so many lies. That's why we're here.
No, we're here because state and the prosecution had
By
to
the end of the
bring
night,
the stupid ass shit to fucking court
is what was in Trayvon Martin's.
because
The defense attorney said, what evidence is there that the defendant followed Trayvon Martin after he said okay? He challenged the state. Well, I've got an answer. What happened after 19/13/43 when that defendant hung up with Sean Nofke? In 19/15/44
you could have
when
used
Rachel
regular
Gentile
time,
heard the thump
dummy.
and the end of Trayvon Martin's life. The defense attorney gave us a nice demonstration of what happens in 4 minutes. Well, what was that defendant doing for those 2 minutes? Watch the walkthrough again. Watch it. Because he tells you exactly where he hung up. He's walking back in the direction of the T, and he says, I got off the phone and I continued to my car. Maybe 10 seconds before he got to the T. It was 2 minutes. 2 minutes. He wasn't going back to his car.
2 minutes. Do you know how long it takes us fat people to walk? You better shut your mouth.
4 minutes is not the amount of time that Trayvon Martin had to run home. 4 minutes is the amount of time that Trayvon Martin had left on this earth.
Oh my God.
I don't have any audio clips for you, or video clips, or charts, or big, long, 10-foot long timelines.
No, you just had your first dude yell at every fucking body.
I'm asking you to
and
use your
now,
common sense.
oh, here we
Use
go
your
again.
heart. Use what you know is
I'll be
real.
right back.
Use what you know you've heard in the law in this case. You know, and for the defendant, it's kind of like their little animation, the cartoon that they put up. Everything they want you to think in this case starts from the T, just like their little animation starts from the T. Don't do that. That's not fair. That's not fair. It'd be like reading the end of a book, the last chapter only. And you'd be asking yourself, why are we here? How did we get here? Who are these people? You can't do that in real life, and you shouldn't do it here. Let me suggest to you, you start at the beginning. Let's start at the 7-Eleven, where that child had every right to be where he was. That child had every right to do what he was doing, walking home. That child had every right to be afraid of a strange man following him, first in his car and then on foot. And did that child not have the right to defend himself from that strange man? Did Trayvon Martin not also have that right? I don't have all the fireworks, all the animation, but come back with me. Come back with me to that scene where it happened that night. Come back with me and bring with you your God-given common sense. The common sense that tells you it's the person talking like the defendant who had hate in his heart, not the boy walking home, talking to the girl in Miami.
Creepy ass
Wow.
rapper.
The common sense that tells you if Trayvon Martin had been mounted on the defendant, as the defendant claims, when he went to get his gun, he never could have got it. I don't have to pull out that mannequin again and sit on it. You remember. If you have to, do it in the jury room. If he was up on his waist is covered by Trayvon Martin's legs. He couldn't have got the gun. He couldn't have. They wanted a reason. It's a physical impossibility. He couldn't have grabbed it. The only way that defendant gets to his gun, the only way Trayvon Martin was getting off of him, or he had backed up so far on his legs that he couldn't hit him, couldn't touch him. The defendant didn't shoot Trayvon Martin because he had to. He shot him because he wanted to. That's the bottom line. The common sense that tells you if Trayvon Martin had already run off like he claimed in his interviews, why would he go through the end of the T to get an address if he had already run off? Does that make any sense? Of course not. It's self-serving. It's justification. It's false. The yelling. Listen, please listen to that tape again. Jen Lauer's 911 call. Listen to when the screaming stops. At the instant of the gunshot, silence, nothing. If that defendant thought he missed Trayvon Martin, thought Trayvon Martin was still alive, so much so that he had to get on his back, flip him over, spread his arms out, why would he stop yelling for help? Why? If he was in fear. Does that make any sense? Of course not. If he was yelling that loud and that long, would he have sounded the way he sounded on the recordings that you have? He wouldn't have been hoarse. He wouldn't have had a strained voice if that was him yelling. Really? That's why common sense is so important. This isn't a complicated case. It's a common sense case. And it's not a case about self-defense. It's a case about self-denial. George Zimmerman. The common sense that tells you if he was the neighborhood watch coordinator, not anyone, the coordinator, who had lived there for 4 years, he'd know the name of Twin Trees Lane. The common sense that tells you if he was so afraid of the real suspicious guy with his hands in his waistband, he'd never got out of the car. But that's not what happened. The common sense that tells you if he really was soft, didn't know how to fight, in his own words, he wouldn't have been able to get wrist control of Trayvon Martin. Those were his words. He wouldn't have been able to move his hand off his mouth or off his gun. If Trayvon Martin was putting on such a blow, that little plastic, flimsy kid's watch on his wrist, it wouldn't have come off. It didn't. The common sense that tells you if Trayvon Martin was the one on the hunt, would he still have been on his cell phone? Would the earbuds still have been in his ears if he was getting ready to attack somebody? Really? And the most important one of all, the common sense that tells you in your everyday life, really, if he hadn't committed a crime, why did he lie so many times? Why did he lie? Let me remind you. Sean Nofke told me to get an address. That didn't happen. Listen to the tapes, listen to the walkthrough, and listen to the non-emergency call. Sean Nofke never said that. I told the police I was going to meet about my car. That's not what he told them. Why? Why lie about that? It's so important. That's why. Because he wasn't going back to the car. He was going back to Trayvon Martin. Just like he said on that tape when he slipped up. Just like he lied about when he was confronted. It wasn't 10 seconds afterwards. It was 2 minutes. Trayvon Martin covered his mouth and nose. Really? They want you to believe that the blood was washed off by incompetent medical examiners. But yet he told the police, not just the police, his best friend, remember his best friend in the world, that Trayvon Martin was squeezing his nose. Do you really think if that were true, there wouldn't be George Zimmerman's blood on these sticks that they pried under his fingernails? Do you really think that's true? That was a lie. Concrete. You're kidding me. It's heavy. It's hard. If his head had been slammed in something like this, slammed, bashed over and over, he wouldn't look like he did in those photographs. Think about it. That would be it. Dozens of times, he said, dozens of times. Punch in the face. That would be it. Was he injured? Yes. Was he injured seriously? Not close. Not close. I mean, they can call their expert and show him all the pictures of the lumps on his head. Were any of those serious? Didn't Trayvon Martin have a right to defend himself too? Remember Lindsey Fulgate? He didn't have so much as a headache the next morning. Not nausea, not vomiting, not a headache. And he didn't come see me for treatment. He came for a note for work. It wasn't that bad. It wasn't bad at all. Would Trayvon Martin's hand look like that if he had been pummeling him? You said Trayvon Martin saw his gun. First of all, it was inside his waistband. Inside. Second of all, Trayvon Martin's legs were covering it. He couldn't have got to it. Trayvon Martin couldn't have seen it. Do you think for a second, seriously, do you think for a second that if Trayvon Martin had seen that gun ever, there'd be a gunshot at 90 degrees in the center of his chest? Do you think that? I mean, Mr. Stay Puft, Mr. Softy was going to be able to get a shot directly through the center of his chest with Trayvon Martin knowing that gun was there, fighting for his life. Do you think that? Why was it so important to say he spread his arms out? Because he had to make Trayvon Martin menacing, violent, threatening. So I had to put his arms out. They weren't. They weren't. They were not. They were clutching the bullet wound on his chest. The car. He had to make him sound menacing to justify what he had done. Listen to those tapes again. There's the only two you have to listen to. The walkthrough and the non-emergency. Play them side by side right after each other. It's physically impossible, the way he told the police, impossible, that Trayvon Martin ran behind those homes, came back and circled his car. Why is he lying? He didn't want to know about Stand Your Ground. Didn't want the police to know he knew about it. Stand Your Ground, what's that? And let me suggest to you, in the end, this case is not about standing your ground. It's about staying in your car, like he was taught to do, like he was supposed to do. And he can't now cloak himself with the noble cause of a neighborhood watch coordinator, violate its cornerstone principle, and expect you to absolve him of his guilt. He changed the story. This is where he told Singleton he first saw Trayvon Martin. And this is where he showed him on the walkthrough. Watch the walkthrough again. Why did he lie about that? Why was it important that he came in through that cut like everybody else had told the police? That he came through the cut because he had to make Trayvon worse, had to make him worse, more menacing. That's why he lied. He told some people Trayvon Martin said one thing, and then it got worse. He told him he said something else. He reached for my gun. Had to make it worse. So he told Mark Osterman, his buddy, no, he grabbed my gun. He told him between the hammer and the back. Why? Why is he doing this? Told Mark Osterman, he circled his car at the clubhouse. He told the police, he circled it where he finally parked his car. He never circled his car. Told somebody he got his cell phone out. Told other people he was reaching for his cell phone. That's what he was taught. Don't be a vigilante. Don't. See and call. Don't get out. Don't follow. Don't try. Just call. And they gave a little special book.
Give him a special book.
What not to do? What did he do? And think about this. The defense referred to George Zimmerman as a responsible gun owner in their opening remarks. A responsible gun owner. What did he do after the shot was fired? Did he yell for an ambulance? Call 911? Get an ambulance here? I had to shoot somebody? Did he roll Trayvon Martin onto his back so he could breathe? He just stood there and he watched. and he waited. While Trayvon Martin was face down. The bottom line is, who is responsible for Trayvon Martin lying on that ground? Trayvon Martin didn't kill himself. And who's responsible for the state not being able to ask Trayvon Martin to step forward so I could put my hand on his shoulder? I'd love to do that. Who's responsible for that? And Trayvon Martin is not, was not, will never be a piece of cardboard. To the living we owe respect, but to the dead we owe the truth. It probably seems like a year ago that we were all in here, one by one, and then as a group in jury selection. And one question got a smile from everybody, but it's important. When the attorneys asked you, do you understand it's not like TV? It was an important question, because it's not. And now you know, it's not like TV, where all the witnesses are well-dressed, well-educated actors and actresses. There are no Rachel Gentels on CSI. And they don't call people like Kristen Benson, who found nothing and a fingerprint from the gun on Law & Order. It's not like that in real life. In real life, we give you everything. The good, the bad, the indifferent. Because when that defendant is entitled to a trial, he's entitled to a fair one. All of it. All of it. And now you have that. In Hollywood, they write it up the way it happens on Sunset Boulevard. But in real life, it happens just like it did on Twin Trees Lane, in front of so many good, unsuspecting people.
But also did nothing.
And remember, if you get back there and you don't like some of the witnesses in the case, you don't like Rachel Gentel or Shipping Bow, or the fact that there isn't this evidence, or the fact that there isn't that evidence, ask yourself, who produced this trial? Who made up the witness list?
You?
Who created the evidence? Who chose the circumstances? Who chose the lighting? Who chose the time? Who chose the weather conditions? It wasn't me. It was the defendant. He chose everything. And that's why we're here. And that's why the evidence is what it is. But it is
They
enough
chose to prosecute.
with your common sense. It is enough. And I'm not asking you to fill gaps.
That's
I'm asking you to
That
do
is a
what you
lie.
do every day. Start from the beginning. Get to the end and apply your common sense. And don't misunderstand me. Your verdict is not going to bring Trayvon Benjamin Martin back to life. Your verdict is not going to change the past, but it will forever define it. So what is that? What is that when a grown man, frustrated, angry, with hate in his heart, gets out of his car with a loaded gun and follows a child, a stranger, in the dark, and shoots him through his heart? What is that? Is that nothing? That's not anything? Is that where we are? That's nothing? Well, that's not his call, and that's not my call. That's your call. And I submit to you, the oath you took requires it. Trayvon Martin is entitled to it, and that defendant deserves it. Defense counsel went through this with you. I just want it real quickly because it is our burden, so indulge me, please. A person justifies the use of deadly force if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm. I mean, they can put this picture up. You know, they blew it up for you. It's bigger than life size. It's colored. That's a fact. That's reality. That's what he looked like that night. When you wipe the blood away, that's what he looked like. Did that man need to kill somebody? Need to kill a teenager? They put up pictures of all the witnesses. I forgot that one. The defense attorney said it is, well, ask yourself, you know, if there's an issue about who lost the fight, ask yourself, who lost the fight? Who lost the fight? Who lost the fight? That's all evidence. Those are all facts. In deciding whether George Zimmerman was justified in the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used. He was, they estimated, 18 feet away from John Good. He knew the police were on their way. He knew that people were opening their windows and opening their doors. And when he shot him, he knew Trayvon Martin wasn't on top of him, so he could get his gun. Under those circumstances, under our circumstances, did he really need to shoot? Did he have to shoot Trayvon Martin? No, he didn't. He did not. Before I get to reasonable doubt, let me just go through a couple of things in the time I have remaining that the defense mentioned to you. I wrote down a quote. He said, innocent itself is no protection. Exactly. It wasn't for Trayvon Martin. He said he could have gone home. The guy could have gone home in the same sense. He says, I guess, it seems. Why didn't he go home? Use your common sense. Did he really want to take this guy home with him to the residence where the only person there was 12-year-old Chad Joseph? Did he really want to lead the defendant to that residence? Just like the defendant said, remember, on the phone call, the non-emergency call? I don't want to give out my phone number. Why? Dennis Root said there's no other option for the defendant. For everybody else there is. I mean, he had to admit that. He could have done other things, but except for the defendant, there wasn't another option. But consider this. This is so important when you consider his opinion. The only evidence he had about what was happening at the time the shot was fired was from who? Self-serving statements from the defendant. That was his opinion based on that. And when I asked him,
And the gym instructor.
when I got on the floor, how could he get the gun with Trayvon Martin on top of him? The words were somehow. Like I said, if you don't have to do it, get on each other. You won't get the gun. You won't until you get off.
Have you tried it?
Why give so many statements? The defense attorney asked if he was guilty. Why would he give any statements? Why give so many? Because he had to justify his actions, and that's why it kept getting worse. That's why by the time he got to Mark Osterman, it was completely different. That's why it kept increasing. That's why when he got to Sean Hannity, wow, it was God's plan. By the time he got to Sean Hannity, it was God's plan. Defense attorney mocked me. That's fine. Because I said he pushed the gun into his chest. He didn't. It was a contact wound with his shirt. He didn't push the gun into his chest. A reasonable doubt is not a possible doubt, an speculative doubt, an imaginary doubt, or a forced doubt. And it's kind of funny the way they do the instructions. They don't tell you what a reasonable doubt is. They tell you what it's not. But let me suggest to you, a reasonable doubt is something you can attach a reason to. Use this definition as guardrails for your deliberations. If you get back there and one of you says, well, maybe this happened, or couldn't this have happened? Or is it possible this? That's not a reasonable doubt. A reasonable doubt needs to be two things. It needs to be reasonable, common sense, reasonable. And it needs to go to an element of the crime. If you have a question about something that doesn't go to an element of the crime, and Judge Nelson's about to spell it out for you, probably after the lunch break. If it doesn't go to one of those elements, it's not a reasonable doubt. A reasonable.
Sorry, I apologize. I need to interrupt and approach the bench for a moment. Okay. Or I can state it now.
No, approach the bench.
The statement of the law.
Again, after the final arguments have been concluded, I will instruct you on the law that's applicable to this case. You will be taking that law back to the courtroom with you. Thank you. You may proceed.
Thank you, Judge. Listen to the court when you get the law. This is what she'll tell you. A non-reasonable doubt, something that's not reasonable, possibility, imaginary doubt, or forced doubt, must not influence you to return a verdict of not guilty.
Oh, you didn't get
one more thing with you.
go on your tirade.
And that was, it was brought up actually by the defense. It was brought up by the defense in their summation this morning, and it was brought up by the defense in the trial. Not by the state, but by the defense. Race. This case is not about race. It's about right and wrong. It's that simple. And let me suggest to you how you know that for sure. Ask yourselves, all things being equal, if the roles were reversed, and it was 28-year-old George Zimmerman walking home in the rain with a hoodie on to protect himself from the rain, walking through that neighborhood, and a 17-year-old driving around in a car who called the police, who had hate in their heart, hate in their mouth, hate in their actions. And if it was Trayvon Martin who had shot and killed George Zimmerman, what would your verdict be? That's how you know it's not about race. To the living, we owe respect, but to the dead, we owe the truth. What do we owe Trayvon Martin?
Oh, yeah.
16 years and 21 days. Forever. He was a son. He was a brother. He was a friend. And the last thing he did on this earth was try to get home. This is the day. The self-serving statements, the lies from his own mouth, and the hate in his heart. Words that they can't now take back. The physical evidence.
You should have
which
ended with
his
that,
lies.
because that was touching.
And the law that Her Honor is about to read to you,
And
the law
now
that applies to all of us,
you ruined it.
and the law that applies to each of us. This is the truth. Thank you for your time.
Oh my God. Oh my God. Well, that is it, folks. That's it. That's the end. We are finished with the trial. Defense, I think they did really well on their closing. I'm glad it was Mr. O'Meara that did it, because I don't know, I like him better. He has more of a calming feel to him. I like him. And then, well, so how you feel? What do you think? What's happening? Because I mean, I know what happens, but the prosecution, they were just, again, I mean, the second guy, he wasn't as bad as the first guy, but Charlie Brown was just yelling and screaming. And I'm sorry, but if I'm a juror and you're yelling at me, sir, I'm not listening to you no more. You are yelling, and I don't very well appreciate it. And Mr. Guy over here is just being really super dramatic, and he could have kept it very much shorter than that. And I don't know. I just, like, they played it, like, I feel like they played it up. Like, prosecution played it up for the cameras and for everybody else. That's how I feel. I feel like the defense was actually trying to work for their client, and I feel like the prosecution was playing it up this whole time, and just they didn't offer up any alternate scenarios as far as how it could have happened, or what was this and what was that. And all you said was, all you have to go off of is this 911 call that happened before, with him calling him a fucking punk. And then you got Trayvon Martin calling him a creepy ass cracker. Like, you know, it doesn't, I mean, they both were suspicious of each other. And again, like I said at the very beginning, that was a very unfortunate turn of events. And yes, he shouldn't have got out of his car. He should have stayed in his goddamn car. He shouldn't have got out. And none of this would have ever happened. And that would have been that. And it sucks. And I But here we are, and they got into some altercation, and unfortunately, one of them didn't make it out. And that sucks. And I think, honestly, it just really got blown out of proportion as far as, you know, the motivation behind it. And I think the state brought this to trial to appease the public. And it's really sad because they also, when you do stuff like this and it gets political and it does all of that, it gets, you're not searching for any type of truth. You're just trying to get the win, and you don't really care what's happening and what's going on. You just, I don't know. But yeah, okay. Well, that is it. That is the end of the closing arguments, and that is the end of this long video. Hopefully you stuck around and you stuck it out with me. Yeah. So, okay. Well, and the next one will be the verdict, and that will be that. And we're on to the next adventure. So, okay. Peace out.